May it please your lordship. So far as item number 9 is concerned, my colleague has given me an order. It shows that it has been complied with.
Judgment and order is it?
That's 14 to 25 passed in WPC 550 of 25. 14 to 25 passed in WPC 550 of 2025. Compliance order is with him.
Mr. So-and-so, as Bonik, the learned counsel appearing on behalf of the petitioner, submits that the judgment and order dated so-and-so passed in so-and-so have been duly complied with. Thus, taking into account nothing further remains in the instant proceedings, the contempt proceeding stands dropped.
May I please, your lordship? My lord, we have filed an affidavit in connection with item number 32, my lord, yesterday.
Lordship, I'm putting response number 4 to 7 in this.
Lordship.
Where?
Lordship, item 32, Lordship. We need some time to go through the.
Huh?
Lordship, we are praying for some time to go through the reply, Lordship. We received a reply yesterday.
Your affidavit. We'll see when the matter reaches. He wants to bring on record that particular document. We'll see when the matter reaches.
Lordship,
May it please your lordship. Lordship, I beg to mention item number 57, your lordship. Your lordship, owing to certain personal problem, your lordship, I'm praying for adjournment of the matter for today, your lordship. Item number 57, your lordship.
There's a stay.
No, your lordship.
What is the matter about?
Lordship, a notice of eviction was issued, your lordship. Thereafter, we came to this court, your lordship. The court has just held that if any coercive action is taken, then we have the liberty to bring it not to the notice of the court, your lordship. That much, your lordship. The government also has also not filed any filed any response, your lordship.
Did I fix it today?
Yes, your lordship.
So there must be some good reason.
Your lordship has asked
I only
regarding the
asked,
status
no,
of the-
I asked Mr. Bhuya on that day
lordship.
as to whether you like to continue with the present proceedings, taking into account that the government is not taking any action.
Lordship, in this matter, your lordship, I appeared, your lordship. Maybe
You appeared
yes, maybe
Very
this
well.
is the other matter, your lordship.
the request of the learned counsel for the petitioner matter stands adjourned to be listed on 18th of November 2026.
May I please, your lordship, my lord, I beg to mention item 11, my lord. It is a contempt matter, my lord. The government side has filed an affidavit in opposition, my lord. They have mentioned some documents, my lord, which we are trying to collect, yet could not be collected, my lord. So, my lord, we have to file the reply, my lord, in it's the same, maybe given 2 weeks' time, my lord.
When did they file the affidavit?
My lord, they filed it long back, my lord.
And we'll see when the matter reaches. Next.
May please, your lordship. Lordship, item number 8, my lord. My youngest counsel instructed me, my lord. He has been suffering illness, my lord. Kindly adjournment for this day, my lord.
We'll see when the matter reaches. Wait.
May it please your lordship, I beg to mention item number 40. There is a settlement talks been going on, negotiation been going on with the EPFO, my lord. If this matter can be taken up next week, my lord, so that in this week the settlement can be done if it is
To
possible.
get the consent of the other side.
Yes, my lord.
There is a stay order.
Yes, my lord. There is a stay operating. My bank
No
account has been
objection.
freezed.
The request of the learned counsel for the petitioner. And further, as there is no objection from the other side, matter stands adjourned to be listed on 6th of November 2026. Interim orders passed earlier shall continue.
My lord, if earlier, can it be taken up next week since 45 lakh
Absolutely no.
account has been freezed, my lord?
You're there. No
Date in
problem. In the
September, my
meantime,
lord.
compromise happens. Very good. If the compromise does not happen, you have a protection of the interim order.
My lord, so still it's freeze 45 lakh account, 45 lakhs rupees, my lord. Can it be taken up on September?
No.
Any date in September, my lord.
But it's too early. Okay, we gave it earlier. On 7th of October.
I'm grateful, my lord.
May I please, my lord? I will pair for upgradation, my lord. Item number 61 of supplementary list, lordship.
Item number?
61, lordship. If possible, lordship, can it be taken at 2 PM, lordship? That Gosala matter, lordship.
See when the matter reaches. You are asking for money.
Yes, lord.
Money can wait.
Lordship.
Liberty cannot.
May I please your lordship? Lordship, in item number 47, we have filed an affidavit in reply, so the same. Deeply obliged, lordship.
What is the matter about?
Taking up my love, yes, my love.
Huh?
Taking up my love, sub wholesaler license now.
Let us see the impugned order.
In order, lordship.
Where is the impugned order?
2011, lordship. Case 54, my lord.
Huh?
Case 54. Allotment of commodities to sub wholesaler for the month of December.
Why have you done that?
My lord, we have not filed affidavit, my lord, here. Three, my lord, we have filed, my lord. In item number 3, we have filed. Paragraph 4, we have stated, my lord.
What is your stand?
Stand, my lord, that.
Baki kita deduction 1 to 6, why have you given only one? How many matters are there? Give it to me.
This is regarding
The matter.
1983.
What is your stand?
Yes, my lord, in paragraph 4, page 2, my our affidavit, my lord, that
Item number?
numbers of item number 3. Formal Agarwal. Bajaj.
Item number?
3, my lord, petition number 7651 of 16.
Item number 3, I don't find an affidavit.
In our record, my lord, since all matter, 16 matter, my lord, some of the files we don't have, but some.
Got it.
My lord, paragraph 4, my lord. Was existing in Jonai subdivision since 1983. The name and style of Jonai GPF. To leave the storage, go down and. Region, my lord.
Why are all these petitions together? This is against all for the, who are these petitions?
Ramaji. For district, Ramaji.
Who are these petitions?
Same district, my lord. Same, huh? Malino pusaka hai sir. Matlab, only 17 matlab Lawajima has passed order regarding service of notice. That's no problem. If Lordship grant us time, then we can take instruction also, my lord.
No, nowadays
16
this system is not there.
Yes, my lord, that's perhaps by infractures, my lord, perhaps, my lord. Because
It has
16
become
matter,
infractions taking into account in view of the targeted distribution of
targeted
notice.
distribution, my lord, yes, my lord.
Now they cannot leave to you issue tenders.
My lord, accordingly day, my lord, because 16 matters, so my lord. Probably, my lord, some of the cases tips service is not complete, my lord. In all the cases, my lord, my brothers. It doesn't into infractions or something.
None appears on behalf of the petitioner on call. So it is also seen that on various occasions, the petitioner have been asked to take steps upon the the private respondents, which have not yet been taken. This court also takes note of the grievance of the petitioner in the present batch of writ petitions, and taking into account the targeted distribution, public distribution order
This is public.
2015
Income.
system order to silo Wuhan.
16 or okay.
And the manner in which the authorized agency is required to distribute that nothing further remains in the present batch of writ petitions to be decided. It is also it therefore appears that the petitioners have lost interest in the present batch of writ petitions. Accordingly, the writ petition stands dismissed for non-prosecution. Would take it, huh? 1 to 6. Yes, what is your instruction?
That in prospect of that lordship, High Court's order, lordship, that within 60 days, my lord, they have taken the my lord hearing, lord. Petitioner also present under that hearing.
And final order, this one.
Final order would be. Did we just say hearing? Kusum Monty बोला.
An old one.
Lordship.
What is an updated instruction?
Lordship, it was that, it was, the lordship already been disposed of.
Understood, but what has happened in the meantime? There was a direction out there.
Lordship.
Considering that that there are serious disputes with regard to the questions of fact, this court is of the view that the matter should be decided by the deputy commissioner concerned district, namely so and so, into the interstate claims made by the petitioner and the respondent in so and so. We do one thing, Mr.
Lordship.
This order, whatever may be, the direction, the deputy commissioner can't decide this.
Because, my lord, they did not have, there is a malleability of documents, my lord.
It may be, I think,
Lordship.
Mr. Counsel, you need to file a suit.
Lordship.
Because tomorrow what will happen? This court have entrusted a jurisdiction upon the respondent deputy commissioner. Now tomorrow what happens if the moment the deputy commissioner decides it, the other side will immediately come up, what is the jurisdiction of the deputy commissioner? Then he will say that the High Court has granted the jurisdiction. Now can the High Court grant the jurisdiction in respect to a purely civil matter? What is the deputy commissioner is looking out here? If you see this, have you given a copy to him?
Lordship, I will read them.
No, give it. What the deputy commissioner is doing or the additional deputy commissioner is doing, they are taking up steps. It's not that they are not
Lordship.
taking. But at the end of the day, it is a dispute as to who is the owner of the land, who is in possession of the land.
Regarding position, regarding owner, my lord, in their affidavit, they said government land.
Here also they
Lordship.
say it's government land. But the
So,
question is you are there in possession and there is another person is in possession. So therefore you have to apply. If you are possession prior to 2001, you will get it. That's a different aspect of the matter. But if it is a dispute interstate between you and the respondent who is in possession, don't you think that it is a case for which you need to file a suit?
that about, my lord, the regarding malleability of document, my lord, there is a lordship.
The moment it is a case.
And
of
we have filed
manufacture of
RTA, my lord, there is
Mr.
lordship.
Hope, kindly understand,
Lordship.
if there is a case of manufacture of document, you need to challenge the document. And that challenge can only be there before the civil court, not before the deputy commissioner cannot look into it. See, entrusting a jurisdiction upon an authority who doesn't have the jurisdiction. Can tomorrow the deputy commissioner give a declaration that this sale deed is bad? You tell me, with your
No,
great expertise, tell me, can the deputy commissioner say that
Court-
his sale deed is bad?
lordship, it is not sale deed, my lord. It is a record from the deputy commissioner.
So the records have been here. Can the records be said by the deputy commissioner is wrong? You need to challenge it by way of an appeal, or if there is a record out there, you need to challenge it in the proper proceedings. But can the court direct them to look into it in this manner and decide as regards that there is a proceedings, how you could do it? Let's see what is the order passed, what has happened. The petitioner is before his court claims that his father so-and-so had possessed 10 bighas so-and-so of land since the year. The said land is in his possession and was a part of the contiguous land. That the name of the father of the petitioner was recorded in the draft sheet and the said land was under his possession there. Demands the petitioner has been cultivated. The respondent was working as a teacher and so-and-so, so-and-so, so-and-so. Case of the petitioner that the father of the petitioner, respondent number 5, in collusion with the revenue staff, managed to create a new dag, being dag number so-and-so by covering so-and-so by creating a new khatiyan, which is different from the old khatiyan number so-and-so. This came to the created by the father of Iman by order dated in 1972.
Lordship.
The petitioner, having been aware of the aforesaid order, approached the authorities for correction of their name in place of their father by way of. However, the respondent, along with a group of persons, took steps to evict the petitioner from the land, saying that the said land is a part of dag number 20, which has been settled in the name of Iman and converted to Miadi dag number. In view of the dispute between the petitioner and respondent, an application was filed before the Office of the Settlement against the alleged so-and-so. The petitioner has filed a representation Iman on so-and-so paying for necessary action. Now here it says it is further stated in the affidavit that so-and-so requesting for correction of the government caste land by virtue of inheritance and so-and-so. The reply submitted so-and-so. Now, what does the court say? Considering that there are serious disputes as
Right.
to the question of facts, this court is of the view that the matter should be decided by the deputy commissioner. How is he going to decide? Is he an authority? Is he the civil court to decide that? With due respect.
Now, my lord, documents created by from that official, my lord, that's why, my lord, lordship.
In the year 1972, something happened. You have filed an application before the settlement officer. Has the settlement officer passed an order?
No.
No.
Therefore, we have
So
proceeded.
if the settlement officer has not passed an order, you come for us for passing an order, directing the settlement officer to pass the order. It's another aspect of the matter. But can this court direct the deputy commissioner to decide between two factions and look here, who will kindly decide who is in possession of here? Pass a detailed order deciding the dispute between the petitioner and the respondent as to the intersect claims of the petitioner and AI in respect of doc number so and so. This exercise be carried out under 60 days. Not possible. We close this. I hope. Heard Mr. Ali, the learned counsel, appearing on behalf of the petitioner. Mr. J. Hendrick appears on behalf of the respondent, sole respondent petitioners. The present contempt application has been filed alleging willful and deliberate violation to the order dated 21/11/2024 passed in WPC number 5176/2023. A perusal of the order shows that on account of serious disputes between the petitioners and the private respondents in the writ petition, this court directed the deputy commissioner to decide the intersect claims between the petitioners and the private respondents in the writ petition in respect of the land measuring 10 bighas 2 katha 1 lakhs covered by DAG number 373/408 at village Molakhua under Mankasar Revenue Circle in the district of South Salmara, Mankasar. There was also a direction for the deputy commissioner to complete the said exercise within a period of 60 days from the date of receipt of the certified copy. It is noticed that in pursuance to the upon receipt of the certified copy, a proceedings was initiated for compliance of the order directions passed by this court in the order dated so and so passed in WPC number so and so. This notice was issued on 6/2/2025. Today, Mr. J. Hendrick, the learned junior government advocate, have placed before this court
Lordship, it was disposed
the
of on
details.
16/6/25. Disposed of, matlab that.
What is that?
Proceeding has been disposed as per direction of this honorable court.
I placed before this court an order passed on 16/6/2025 by the Additional District Commissioner Revenue wherein it has been noted that one of the parties had filed a suit being title suit number 13/25 before the court of the civil judge junior division Hatsing Mari relating to the land I have passed an order on 16/6/2025. Additional District Commissioner Revenue, South Salmara have passed an order on 16/6/2025. Wherein it was observed that the District Commissioner South Salmara was unable to allot the land to the petitioners without the approval of the land policy implemented by the government. The said order is kept on record and marked with the letter X. Taking into account the above, it is the opinion of this court that the order dated the order having been passed on 16/6/2025, the same would be in substantial compliance to the directions passed by this court. So before parting with the record, this court, however, observes that accordingly, the contempt proceeding stands closed. Before parting with the record, this court, however, observes that the closure of the present contempt petition shall not affect the rights of the petitioners to approach the competent court of civil jurisdiction if so advised. Purely
Right.
civil disputes.
May I please, your lordship? Lordship, I am
The-
appearing on behalf of GRA Mutakir, my lord. He has been suffering illness, my lord. Appearing for adjourn for this day, my lord. Eight.
What is the case about?
No, lordship, my lord.
This court directs the counsel for the petitioner to produce the FIR which was filed before the Baihata Shariali police station and in respect of which the GDE number 310 dated 11/5/2012 was registered. List this matter on 11th of September 2026.
Obliged, my lord.
May I please, your lordship? My lord, the order has been duly complied with. On
Mr.
21
Suenko, the learned counsel appearing on behalf of the petitioner submits that the order dated 31/7/2024 passed in WPC number 5146/2023 have been duly complied with. Under such circumstances, the contempt proceeding stands strong.
Obliged, my lord.
Yes.
My case, lordship,
Mr.
it was, my lord,
Taluja,
originally
when did they
land
file
sale
the
permission, my
reprimand?
lord, composite land sale permission matter, my lord.
Affidavit filed on 22/3/2026.
No, my lord, this is not complied with. The honorable court passed an order on 5/5/25
I'm
to,
not on that. You wanted to file a reply against this.
my lord, if lordship may.
No, if you
dispose of
don't
it.
want, no problem with this. What is the direction? We'll
Lordship
finish
has,
it off.
Lordship has directed us to consider his application, pass a speaking order. And that has been done
What is the
ultimately.
case about?
My
But
lord,
this is
composite
related-
land sale permission, my lord.
Relating,
Huh?
relating to issuance
Direction.
composite land sale permission.
It is now the obligation of the designated public servant to consider the application submitted by the for notified services under the composite strictly in consideration of so and so, the proviso of so and thereafter pass a speaking order. Where's the speaking order?
My lord, kindly take up the affidavit filed by the DC, my lord.
Where?
Page number 34, my lord. Page 34 is the report given by the circle officer to the DC. Why this
Mr.
certificate?
Counsel, where is the speaking order?
Page 37, my lord.
As per the report, the document submitted in respect of the NOC, it is found that the name of the first party which is mentioned in the affidavit does not match with the buyer and the seller. Further, the applicant did not submit the non-encumbrance certificate. The direction was given to whom? The designated public servant.
He's the
Yeah, Circle officer is the designated public servant.
circle officer, lordship.
And the aforesaid above mentioned NOC are hereby rejected. The applicants are advised to apply again along with.
But it is deputy commissioner, my lord, so far as I know.
No,
my
no,
lord.
circle officer is the designated, my lord, he is to consider. the-
Kindly see the, my lord, 38, there is no date even, nothing is there, my lord, page 38. And what the point is taken is also incorrect, my lord.
Page 36, page 36. is
38,
the-
my lord, kindly see, there is no date, my lord.
Page 36 is the forwarding letter. This letter has been, circle officer has given it to the DC, my lord. Page 36.
Huh?
Page 36, my lord.
Page 36.
Yes, my lord. Circle officer Sribhumi has given it to the ADC. This speaking order has been given.
What is the date? It was given
It was on
2nd of February 2026.
2/26. Yeah, my
And
lord.
we have
Second of
submitted it, my lord, on 17/5, my lord.
Huh?
5, my lord. We have submitted the order, my lord, on 17/5/25 to be passed an order in 3 weeks.
Okay, they passed that order.
But that order is also, my lord, dateless, and the point taken is also incorrect, my lord. Encumbrance certificate was there, and my lord.
Is this in connection with your NOCs, the speaking
Yes,
orders?
my lord. Yes, my lord.
Is rejected. Speaking order says that these are the two reasons.
They can very well
You
have
may
those
apply.
and apply.
We apply now. Instead of fighting out here.
Lordship.
My lord, kindly see, there is no date even also, my lord. So carelessly it is. Kindly see in the page 38, kindly see, my lord.
So
The past is backdatedly passed, my lord.
we consider it to be the dated on 2nd of February
Second of,
2026.
not,
Close it. And thereupon, if you want to do it, does it make why should we initiate a contempt unnecessarily? There are actually contempt is for punishment.
My lord, nothing is done in even my lord after fighting. All people have not gone, my lord. They could not make the sale, my lord. For 2 years, my lord, they could not make the sale till date, my lord. For perhaps now it is 3 years, my lord. They could not make the sale till date, my lord.
Could not make the
Sale, my lord, could not exchange the land and money till date, my lord. They are pending till now. Because of no permission, nothing is there, my lord.
no.
After-
Have you applied after this order?
No, I have not applied that, my lord. Again, I have not reapplied. We have not done, my lord.
You apply. If they don't do so, then we can pass orders. It is between is it inter-religion?
Yes, my lord. That's
Now, what do you say about that? It is found that the name of the first party, S. Ahmed, which is mentioned in the affidavit, does not match with the buyer and seller.
my lord, this is purchase. Normally, what happens, my lord? People engage one clerk, my lord, to do all the clerical things.
please,
He normally purchases in his name this affidavit of 100 rupees. Stamp paper he has taken in his name, perhaps. That is is this the reason, my lord? Always it is happened to be so, my lord. It is given to the
Can
clerk.
this
Clerk
court-
makes arrange
But
everything.
Mr.
Party
Talukdar,
used to
can
go and
take judicial notice of what is happening. It's wrong, I admit. I could see in many cases where they have cancelled the permission on the ground that the value of the land has not been put. You also know, I also know how in the DC office, why the particular value of the land is not put. The value of the land is not put on the ground, that after that, the Mondal or whoever will put it after carrying out that verification. He will put it. Now, these are excuses now being taken, but you can't keep it blank also.
Every day, my lord, they are doing all, my lord, many things like this, my lord. But now they have changed it. It is just, my lord, suffer subject to correction by your lordship, my lord. Payment is the main issue, my lord.
Huh?
My lord, government fees in terms of stamp, my lord, non-judicial stamp. That is the main issue. It is paid, my lord, and just in the name of the clerk, my lord, he has taken it, my lord. Now they are bringing it out before your lordship that it is so and so, so and so. And it's every day they are.
There is an apparent mistake in your application. One, did you submit the no encumbrance certificate? No. Isn't it there a requirement as per the list given?
My lord.
The non-encumbrance certificate, isn't it a requirement?
My lord, if your lordship is satisfied on that, after fighting for 2 years and 3 years, and after fighting the case, order being passed, being submitted in month of May, my lord, and their dateless order is given in February by bringing some, my lord, minor issues. If your lordship is satisfied, I have nothing to say. Please close the case.
No, my
It is up
question
to your
is-
lordship. It is up to your lordship.
No, very well. My question is, are these faults there or not? If are the faults out there, they are right.
They are passing the order, my lord, in spite of, even after submitting the order from this honorable court with the source, they are passing after months. So much negligent towards, even towards the courts, my lord. This is, if it is nothing, my lord, it's up to your lordship.
I heard Mr. A.K. Talukdar, the learned counsel, appearing on behalf of the petitioner. Mr. D. Nath appears on behalf of the respondent numbers 1 and 2. The present contempt application has been filed alleging willful and deliberate violation to the judgment dated 5/5/2025, passed in WPC number 1493/2025. Wherein,
And kindly, my lord, once again, my lord, if your lordship kindly permit
don't
me.
disturb now. Wherein the learned coordinate bench of this court had set aside the rejection order and directed the designated public servant to consider the application submitted by the petitioners for notified public service, composite land transfer, sale transfer strictly in compliance to Section 7(2) of the ARTPS Act, the provisions proviso to Section 21A of the Registration Act 1908, and the notification dated 11/11/2022, and thereupon pass a speaking order within 3 weeks from the date of submission of a copy of the order by the petitioner at the office of the designated public servant. Full stop. The copy of the order was served on, when did you serve?
My lord, 1905, my lord.
How do you know?
Lord, Annexer B, my lord, there is Annexer, they received it, signature, my lord.
Whose signature is this?
Kindly see the, my lord, there are numbers, Annexer B, my lord.
Annexer B is by, you are sending it by some docket.
Yes, my lord, advocate, and twice submitted on 2 dates.
Where is the receipt?
No, though they did not give any receipt, my lord. This is very difficult, my lord. Just
Was submitted on 28/5/2025. And no order thereupon being passed. the petitioners have been compelled to approach this court by filing the present contempt application. Full stop. An affidavit was filed by the respondent number 2. Stating inter alia
Para 5, my lord.
that the circle officer Sribhumi Sodor Circle at whose level the application of the petitioners are to be considered was directed to process the NOC applications filed by the petitioners and to take necessary action in pursuance to the order dated 5/5/2025 in WPC number 1493/2025. Was submitted on 17/5 date, 28/5, not 17/5. Mr. Counsel, where is Annexure A?
My lord, the lordship kindly see, ADC has signed, ADC Sribhumi 19/5/25. At page number 33, my lord, towards the bottom.
The records reveal from the affidavit filed by the respondent number 2 that on 17/1/2026, the circle officer Sribhumi Sodor Circle issued a communication to the district commissioner Sribhumi informing that the name of the first party, S. Ahmed, which was mentioned in the affidavit, did not match with the buyer and seller. And further, as per the LR report, the applicant did not submit the non-encumbrance certificate along with the aforesaid application. It was further mentioned that on account of these discrepancies, the aforesaid applications were rejected. Subsequent thereto, on 2nd of February 2026, an undated speaking order was passed by the circle officer Sribhumi Sodor Circle, thereby rejecting the petitioner's application on the ground that the name of the first party, S. Ahmed, was not mentioned. First party, name of the first party, S. Ahmed, which is mentioned in the affidavit, did not match with the buyer and the seller, and further the applicant did not submit the non-encumbrance certificate. Considering the above, it is the opinion of this court that there has been substantial compliance to the judgment and order dated 5/5/2025 in WPC number 1493/2025. This court also takes note of that this court also takes note of the submission made by the learned counsel appearing on behalf of the petitioner to the effect that the order was directed to be passed within a period of 3 weeks from the date of submission of the copy. However, the order was passed, an undated order was passed on 2nd of February 2026. This court takes strong exception to in the manner in which the district commissioner Karimganj, Sribhumi, Sribhumi, as well as the revenue staff, more particularly the circle officer, have taken time in disposal of the applications by passing a speaking order. We initiate as the authority that it will come within the ambit of misconduct and disciplinary actions should be taken against the
No,
district.
Malad, kindly,
No.
kindly see, Malad. Annexure A, Malad, they,
No.
the circle.
No, whatever may be. The direction was to the designated authority. The order, the moment it was given, wasn't it his also responsibility?
The order, in fact, they have not
Under
filed
such
the,
circumstances,
kindly consider, Malad.
this
they
court
have not-
observes that such inaction on the part of the officials in delaying in delaying by 8 months, almost 8 months. 8 months?
Yes, ma'am.
Is in utter disregard to the timeline stipulated by the directions passed by this court. In the opinion of this court, that the said aspect constitutes a misconduct. This court would not further like to proceed with the present contempt proceedings in view of the passing of the speaking order, but would leave it to the wisdom of the respondent authority, the wisdom of the Commissioner and Secretary, General Administrative Department to pursue as to whether disciplinary proceedings should be initiated against these officials for apparent delay in complying with the order. Contempt proceedings accordingly stands disposed. The disposal of the contempt petitions shall not preclude or prejudice the petitioner to file appropriate applications for seeking NOC if so advised.
Oblige, your lordship.
Mr. Nath, the speaking order which was passed, yeah, does the circle officer know how to write a speaking order? Doesn't he know that a speaking order should contain a date?
He should have
Huh?
passed in a more proper way, my lord.
He passes a speaking order. This is, first of all, you have also not shown that he is the designated authority.
No, he is, my lord, para
Ah,
18.
where is the document?
No, para 18 of the Honorable Court order is clear. The order by which the Honorable Court has disposed of the matter, because earlier he rejected the application. Honorable Court said that rejection is only 2 words, rejection. There is no reason. Therefore, he was directed to pass a speaking order. Para 18, my lord, if lordship kindly takes up, my lord. Circle officer is the authority, my lord. Para 8, if lordship for a moment takes up para 18 of the judgment, my lord.
No. Is he the designated authority?
Yes, my lord. Yes, my lord. So the application has to be considered by him. Para 18 is very clear, my lord.
But then why didn't so then
They
it
have,
will be limited to the circle. This observation will be only limited to the circle officer, not the
lordship,
district
lordship.
commissioner.
And they have filed the application before the district commissioner. Ultimately.
But anyways, are you saying that the district commissioner, from the district commissioner to reach the circle officer, it has taken 5 months?
I don't know that I have not seen, that I have not asked them.
So then we obviously take it up with the district commissioner has been involved. He was a party to the proceedings. Then,
But they could
and
have,
apart from that,
could
whatever
have-
may be,
they could have very well given it to the circle officer because they.
yes,
know-
why didn't you give it to the circle officer?
My lord, we have submitted it to deputy commissioner. We were
You should have submitted to the circle officer. The circle officer is not made a party in the proceedings also.
My lord, circle officer is not the designated officer. So far as our knowledge is not designated officer.
Who rejected earlier?
My lord, we were not aware of the rejection.
Who
My
rejected earlier?
lord, so far as I remember, it is deputy commissioner. My lord.
No.
Para 18.
My lord, what happened, my lord? It was known to the court files only. We were not aware of all these things. Only after the affidavit being filed, we came to know our rejection.
Who rejected? The rejection has been set aside.
Lordship.
You challenge the rejection,
Yes, my lord.
then if the rejection has been set aside by the circle officer, that means he is the designated authority. And why didn't you give him a certified copy? The direction was for certified copy against him only.
My lord, if I am not wrong, my lord, it is deputy commissioner, my lord.
No. The question is, when there was a direction to the designated officer, did the court hold that the circle officer is not the designated officer?
Normally, even my lord,
Mr. Talukdar, come to the point. Did the court hold that the circle officer was not the designated officer in that order? So therefore, the person who rejected earlier was the circle officer. You were supposed to submit the certified copy to the circle officer. But you gave it to the DC. And you have not made even the circle officer a party.
my lord, that's true, my lord. Yes.
Close Kuriba, and accordingly, in view of the passing of the speaking order, the contempt proceeding stands dropped.
And
I'll help you.
No problem.
But that doesn't go without saying
The
that you need to improve your this district administration.
quality of the
They
order.
don't know how to write a speaking order.
without memo number also, my lord, your lordship.
Huh?
We screen without memo number also.
They don't know how to write.
No,
Teach them
That's true. That's true. my lord.
how it is given.
This could
And you need to then, it's high time that don't give this designated authority to the circle officer because they don't know head or tail anything about law. Don't give it. I only thought that the executive engineers of the PWD or the PHE were worthless. These are more. Your circle officers are absolutely worthless. They don't know how to write a speaking order. He say so and so. I think it must have been on 17/1/2026 when he wrote that letter to the DC. The DC must have said, put a speaking order. So he took one paragraph of that letter and just inserted it without anything and then sent it immediately. It seems must be the same.
It
Not
seems.
even served on us also. It
It
came to
seems,
the
it
after
seems.
contempt. We came to know from contempt. Not even served on us, my lord. Not given copy to us. My
I
lord.
think it's high time. The
Lord,
circle officer is useless.
May I please, Lordship?
Yes, what is
Lordship,
it?
in this case, notice
These
return
also
unserved,
contempt.
Lordship.
What has happened?
Notice return unserved, Lordship. And Lordship, I have instruction that Lordship, the present district commissioner is changed.
What is the directions?
Direction, Lordship,
The petitioner does not fall under the explanation 2 of so and so. In that view, this court does not find any infirmity in the impugn order. While disposing of the widow without interfering with the impugn order, the petitioner
Considered
is granted
application.
liberty to file proper application before the commissioner for allotment of land for rural. If any application is filed, the authority competent to deal with it will examine the same in the light of clause 3 of the and dispose of the same by passing a speaking order, and the petitioner shall be notified about the speaking order. Very difficult. Very difficult. These type of directions cannot be complied with because of the fact that you have submitted an application for allotment as per the land policy. How can there be a speaking order passed? Whether you get it or not, they will reject or may not give it. Now they have a timeline. Yes, who is their revenue? But you have a timeline for allotment, means you dispose of the application within the timeline. Yeah. Get hold of another counsel who knows better of the revenue, not you. Ask anybody. You know anything? Because if I'm not wrong, in respect to those Basundara applications, there it was given within not 365, something less, 10 months or something. There used to be that within 10 months, if it is not, they at the time of receipt, they give it, that within so much time, if it is not granted, it will be deemed to be rejected or something to that effect. The speaking order, when you submit, there is a speaking order. Now tell me, where is your application for allotment?
application, Lordship, I have filed before the district commissioner at page 18.
This can't happen, Mr. Counsel. Allotment application cannot be like this. Prayers for settlement or allotment. Allotment application has to be filed online, isn't it? Anybody from the government? DC? No DC. Where is the DC? Allotment application is to be filed how?
For the first, it has to be circle officer, my lord. After verification, it has come to the deputy commissioner.
It has to be submitted online.
Online, my lord, by way of that notification in the portal, RTPS,
What?
public service, my lord.
For allotment? No. Allotment application is not under right. Is it under right to public service? You don't know. And get hold of any person who knows. Both of you also don't know anything. Huh? Yes. This is a Seva portal you have to file. You cannot file in by way of this and they can pass an order. That is why I'm saying that order appears to be incorrect. Yes, you will submit it by the Seva portal, and after that, if they don't do it, then you may have a case. Now your case has gone on a different tangent. Because you cannot be given a separate treatment because of the fact that you have filed a writ petition. So you have to be treated along with the others. So your case is that if you are to get in terms with clause 3, you have to apply in the Seva portal. Once you apply, if you don't get it, then we'll consider.
The acknowledgement, they have given the time frame.
How much? They give a time frame that within so and so your application will be considered, or if it is not, then they give a rejection.
I will instruct. Lordship.
Do that. Now, we'll close this thing. We're giving you the liberty to do that. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. The present application has been filed by the petitioner alleging willful and deliberate violation to the order dated 6/12/2024 passed in WPC number 6239/2023. It is relevant to take note of that the learned trial court, but the learned coordinate bench, while passing the said order, while No, in the order dated 6/12/2024 did not interfere with the order dated 19/9/2023 passed by the District Commissioner Hailakandi. On the ground that the petitioner did not fall under the explanation 2 of clause 1.7 of the Assam Land Policy of 2019. However, the learned coordinate bench of this court, while disposing of the said petition, granted liberty to the petitioner to file proper application before the competent authority for allotment of land for homestead in rural areas. It was further observed that if such application is filed, the authority competent to deal with it will examine the matter in the light of clause 3 of the land policy of 2019 and dispose of the same by passing a speaking order, and the petitioners shall be notified about the speaking order. On account of the petitioner thereupon submitted an application on, what is the date of your application?
Lordship,
On 13/12/2024 to the District Commissioner Hailakandi, along with a certified copy of the order dated 6/12/2024, passed in WPC number so and so. This court duly takes note of that the direction so passed by the learned coordinate bench was to the effect that the petitioner has to file a proper application before the competent authority. In this regard, this court inquired with the Standing Counsel of the Revenue Department, Ms. So-and-so, who submitted that for filing an application seeking allotment, the same has to be done in the Seva portal.
Seva Setu portal.
Seva Setu portal, and not by submitting a hard copy of the application before the district commissioner. Taking into account the above, it is therefore the opinion of this court that the petitioner had not submitted the application in a proper manner. And consequently, this court cannot, consequently, the question of there being non-compliance to the order dated so-and-so, passed in so-and-so does not arise, for which the contempt proceeding stands dropped. Be that as it may, this court, however, observes that in the circumstance the petitioner submits an application seeking allotment in the Seva portal, the competent authority shall duly consider the same within that, as per the Assam Land Policy 2019, and more particularly taking into account the clause 3 of the said land policy. The petitioner shall also enclose a copy of the order dated 6/12/2024, passed in so and so, along with the application so submitted in the Seva portal, and a copy of the present order. Contempts dropped.
This contempt petition are regarding non-release of the contextual dues, my lord. In the meantime, my lord, budgetary allocation has been done, my lord. Funds has not reached the GMC. Budgetary allocation has been made, my lord. Funds has not.
So you found out. Earlier you were saying that you got the fund, you could not say
Some
that
other-
whether
other
this
fund has
fund
come.
was in respect to this.
Other funds,
No,
funds has come.
Mr. Borat, this matter I've been taking for some time.
Yes, sir.
Earlier was, you did not get any fund for this project, you got for something.
my lord.
Then you got the money, but you could not find out as to whether this money belongs to this.
In 2021, 2021, this.
Now you have asserted.
That the already budgetary allocation of this particular fund had not come to the GMC, my lord.
As of now also.
Yes, my lord. As on today, this funds has not come, my lord. So it will take some time, my lord. In the meantime, we'll release it the moment the fund comes.
The Mr. Esbor, appearing on behalf of the contemner, submits that immediately upon receipt of the funds, the amount payable to the petitioners in the present batch of contempt applications would be disbursed. Considering the above, list this matter on 12th of October 2026 for an update. First, in the meantime, upon receipt of the funds, the GMC authorities shall release the funds to the entitlement to the petitioners.
12, 13, and 14, my same order. This all three cases, my lord.
Highly obliged.
Yes, what is this?
As per the office note dated 13/8, my lord, we have been asked to amend the cost title, my lord, as regards the address of respondent number 6, my lord.
Then,
I may be allowed to amend the cost title, my lord. We were supposed to take steps upon respondent 6. The address has earlier it returned unserved, my lord.
how can the officer in special duty of Lozima Court ask you to file a cost title? Huh? Possible.
Not possible. There's a judicial order has to be passed. Judicial order has to be passed.
Now you have taken address on a respondent number 6.
No, I had taken steps, my lord, on 11/8 I had taken.
Why have you taken in a wrong address?
The wrong address means earlier the steps was that was the address which was provided to me by the client. Now we have taken steps in the Calcutta address, my lord. There is another address.
Has it been served?
Because the steps has not gone because of this office note of the OSD, my lord. It
Obviously,
stays,
you need to file a cost title, but it is for me. I have to give you.
yes, my lord.
Then,
We had taken steps on
what is the
the
address?
on 11/8 on the Calcutta address, the fresh new address.
Calcutta is so small a town, no? It is nearby to Gauhati. Very near.
No, the address-
What is the address?
16A Brabon Road.
You got to stay.
There's no stay, my lord.
This performer. Great. Now argue your matter.
My lord, I was appointed as a receiver, my lord,
Then,
by order dated 15/2/2025 at annexure 25, at page 25, my lord.
directing
By the
owner to direct
Provident Fund
the account
Organization.
Number and GST number of neutral funds in respect. Directing the respondent number 2.
Then, my lord, an agreement was entered into between the petitioner and the respondent 3 for managing the garden. At page 26, it starts, my lord.
This case.
The case, my lord, relates to, my lord, since I'm a receiver, I have to manage the garden and the tea proceeds, the tea leaves, the tea output has to be sold through the auction. So the tea board has not allowed, they had filed an application at page 51 for allowing me to sell my tea through the tea auction. And for that, the bank account has to be registered, my lord. So that application has not been considered by the tea board. At
So
page
you are against the T board.
tea board.
Who is paying for the T board?
Tea board, we had taken steps, my lord, through Dusty. An affidavit service was filed, my lord.
The service complete.
Yes, my lord. We had taken the steps at page 53. The affidavit of service, my lord.
T board. Why they are not representing?
It was received on page 59 at 10:50 a.m.
And who is the other one?
Other one is
Why the
Guwahati
seal is not there?
Tea Auction Center is there. They are also a party. Tea Auction Center is respondent 5. My friend is appearing for respondent 5.
Who is respondent number 2?
1 and 2 is Tea Board.
You served upon whom?
2.
Not 1.
1 and 2, it had gone to both, but the
Huh?
Guwahati address had received it, my lord.
Who has received it?
Guwahati address, the Tea Board, respondent 2, my lord.
No. Respondent number 1 is Kolkata.
Kolkata, my lord.
Respondent number 2 is
The Guwahati office, the zonal office, my lord.
Tea Board of India, so and so. Tea
Both are
Board,
served, my
so
lord.
and so. You have served it to Calcutta.
Calcutta.
Who has signed this?
The Guwahati office.
Who has signed this at page 56 of the Dusty? Not done properly.
This is the Guwahati, respondent 2, my lord, the Guwahati address.
No. And why is the deputy chairman representing the Tea Board of India?
And there's why page 56, my lord.
No, why is the deputy chairman representing the Tea Board of India? What is this type of address? Tea Board of India, Ministry of Commerce.
Page 56, my
No, this name by name. Why you have put these names is also not proper.
page 56 may already be seen also. Respondent 1 has also received, my lord.
Then why haven't you made the executive director not a party? Keyboard is different.
It was received on 15 July, my lord.
I
56.
think we will have it in the month in 2027 sometime.
And my
Everything
friend is appearing for the respondent 5, my lord.
Who are you?
Tea Auction Center, Gauhati Tea Auction Center.
What is your stand?
Miss, the tea leaves which were produced, that has to be supplied, sell through us, but it is by the tea board again.
You filed your affidavit.
No. I'll file, I'll file it.
What is the relief claimed against you? And where is your agreement?
My lord, agreement is at page 26, my lord.
For?
It's between 3 and 4 and the petitioner, my lord. We were asked to manage the
Rahul Chaudhary, Om Prakash so and so. And who is paying for the recovery officer? Yes, what is this type of things? You enter into agreements, such agreements? Is it ever heard of that the recovery officer puts his name out there? I, Rahul Chaudhary, son of so and so, presently working as so and so.
they have in fact, my lord,
These agreements can be with whom?
He's a recovery officer and assistant PF commissioner also.
Huh?
Assistant PF commissioner of Silchar also.
Where is the order that he is being appointed as the receiver?
25, my lord.
Yes, 25. It's a 15 to 25 plus.
See, the agreement has to be with this AETPF,
Yes,
not with the recovery officers. Because you see, the recovery officer acts only as a part of it.
Yes.
Who gives him the authority? The authority is given by this organization. That look here, the provision fund has not been given to me, so you kindly do it. File your affidavits, all of you, file your affidavits. And this side can't help you. The service doesn't seem to be complete as regards to respond number 1.
No,
The
one,
court have taken note of the Dusty, sir, affidavit of Dusty. So filed by the petitioner. And paragraph number 1 and paragraph number 2, it is mentioned that Dusty was, that the service by way of Dusty was delivered and received by the respondent number 1 on 15/7/2025 and on behalf of respondent number 2 on 10/7/2025. The said affidavit is bereft of material particulars as to who received the service upon the on behalf of the respondent number 1 and 2. Considering the above, this court therefore rejects the service upon the respondent number 1 and 2 meted out through way of Dusty. So accordingly, the petitioner is directed to take fresh steps upon the respondent number 1 and 2 by way of Dusty routed through the registry of this court and file an affidavit of service on or before the next date. This matter on 7th of October 2026. The respondent 1,
3 and 4.
3 and 4 and 5 who are duly represented shall in the meantime bring on record their stand by filing the affidavits.
May I please, your lordship? In this case, lordship, I for stay and another I have already filed another IA lordship for amendment of the writ petition. So amendment of this instant writ petition, I have filed an IA lordship. That is not in the record, lordship. So lordship may take it up in some other day, lordship.
What are you challenging?
Challenge the order of the revenue board, lordship.
Why?
But because I was the respondent in the revenue board, lordship, and revenue appeal was allowed, lordship. There are 3 dark numbers, lordship, 146, 148, and 108, lordship. And I have purchased these blend of 3 darks by way of my sale deed, lordship. That is the case, lordship.
Yes, what is your ground of challenge?
Ground of challenge, Lordship.
Not ready?
Lordship,
Not ready?
not ready, Lordship, today. The late Lordship that I may be tagged with the record.
What
Lordship,
I?
for amendment of this particular repetition.
Why?
Some new facts come to light, Lordship.
No new fix. We have to decide on this. I won't even look into your repetition. Whatever you want to say, say.
And
Tell me.
some other day, Lordship.
Tell
Today I
me.
am not prepared, Lordship.
You don't have a case here.
Lordship.
No case.
Some other day, Lordship. Some other day.
Don't you think that you need to go to the civil court now?
Already filed, Lordship.
Then
Paying for
it is civil
declaration.
court who has to look into this. The mutation is only as regards the revenue entry.
Lordship.
It will not impact you in the civil suit. Who has filed the suit?
He has filed, Lordship.
Then
Declaration of his right title.
like
interest.
observe that and close this petition. Unnecessarily fighting out here makes no sense. Do whatever you feel like.
Lordship. Close. Lordship.
Better off.
Lordship. Dispose of.
Petitioner herein heard Mr. So-and-so, so-and-so. The petitioner herein is aggrieved by the order dated by the judgment dated 8/7/2025 passed in case number RA 37 RA, case number 37 RA bracket N oblique 2024, whereby the appeal filed by the respondent number
Three.
the respondent number 3 in the present proceedings was allowed, thereby setting aside the mutation which was granted in favor of
The petitioner.
the petitioner by the mutation order dated 6/5/1998. The learned Assam Board of Revenue further, by the impugned judgment, set aside the order dated 11/9/2023 of the learned ADC Nagaon in miscase number 122/2023 and directed that the record of rights be corrected to its status prior to 6/5/1998. It has been drawn, the attention of this court has been drawn to the fact that the petitioner have already filed an appeal, a suit,
Title suit number 59/2020.
being title suit number 59/2026,
2026.
which is pending before
Civil Judge Junior Division number 1, Nagaon.
this court of the civil judge, learned court of the civil judge junior division, number 1, Nagaon. So it is relevant to take note of that it is well settled that, that mutation neither creates any title nor extinguishes any title. Mutation is carried out only for the purpose of collection of revenue. This court have also perused the impugned judgment, from where and from the said judgment it appears that questions pertaining to right title and interest between the petitioner herein and the respondent number 3. There are there are inter se claims between the petitioner and the respondent number 3 as regards their right title and interest in respect to the land in question. Such claims can only be adjudicated by the court of the by a competent court of civil jurisdiction. Taking into account the suit has already been filed by the petitioner, this court observes that the decision in the said suit, that the impugned judgment shall be subject to the decision of the said suit. In view of the above, the writ petition stands closed. I close.
Obliged.
Contempt application, my lord. Here, the petitioner, my lord, as a registered owner, my lord, applied for mediation of a plot of land on the basis of the sale deed. But the mediation application, my lord, could not be considered only on the ground that the, my lord, land record of the revenue village was not digitized, my lord. So ultimately, in the writ petition, my lord, the honorable court was a direction. Lordship will find the relevant portion, page 13. During pendency of the writ petition, it was brought to the notice of the court that the process of digitization is under process.
My lord, this has consumed some time due to the ongoing process of digitization of records. I have received the instructions, if Lordship may be pleased to, because this honorable court had, my lord, directed to complete the process of digitization within a period of 1 month. And
That is
thereafter,
not possible.
yes, and then thereafter, my lord, the mutation petition submitted by the petitioner be brought into a logical conclusion within an outer limit of further 2 months, my lord. Now, here, my lord, a vendor was, my lord, engaged by the authorities to carry out the digitization process. He had done the work, my lord, to some extent, and he left the work. And then again, my lord, he has been asked to complete the digitization process. And one email, my lord, I have annexed that
Has
is
the
the,
Revenue and Disaster Management Department have issued any notification to the effect that pending digitization, there shall be no mutation proceedings taken on record or decided?
per se, there is none, there is no such
Under
notification.
such circumstances, when a mutation application has been filed, as it is the mandate of the Assam Land and Revenue Regulation, don't you think that it is required for you to dispose it of?
Yes.
Digitization is for what? You are only going to insert somebody's name or whatever may be or in the process. Let you go ahead. I'm not on that. It may be a correction, whatever may be, it can be updated. But the process of mutation cannot stop. So therefore, carry out the mutation and finish it off on the basis of whatever contemporaneous materials are there. Look into it. He filed an application for mutation. What
Yes.
is the mutation? You need to see, get the report from the lot mandal as to whether he is in possession or not, one. And secondly, whether he has the prima facie title. That's the requirement. Once you do it and finish it off. I don't think that the digitization process have anything to do. Or do you insert the digitization, the lot mandal's report in the digitization? No.
No, that is not the case, but here Lordship will.
So therefore,
Yes.
unnecessarily, one need not complicate the issue that there should be a digitization then to do the here, because there is no order to that effect
Yes.
by the department.
Yes, madam.
So and more particularly, when merely because of the digitization, now can we say tomorrow that all the government, because there is a direction for the government to file all the affidavits through e-filing. Okay. Very well. We say we are still going on into the question of digitization. We won't keep any of the government's affidavit on record. We won't. Can we say that? If that be so, here the same principle will apply. Carry out and finish it off next month, give it us. Unnecessarily.
Lordship, maybe please to make some observations.
I'll make it very clear.
I will, it will give me a handle
make it
my lord,
very
to
clear.
persuade the authorities.
It's okay, I'll make it clear. You see, the question of this court directing them to complete within 1 month, it is cannot be conceived of, with due respect. This court cannot conceive of. But the fact remains that the mutation cannot be kept on hold because of the other thing.
So that is a statutory requirement. We
That's
have
a
to,
statutory.
there is no escape. Yes,
Dekho.
yes.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. R. Pujari appears on behalf of the respondent number,
All the respondents, 1, 2, and 3.
all the respondents.
One was not a party respondent in the writ proceedings.
That's okay.
Yes.
1, 2, and 3. The present application has been filed alleging willful and deliberate violation to the order dated 12/8/2025 passed in WPC number 3045/2025, whereby there was a direction whereby there was an observation that the digitization process would be completed within a period of 1 month, and thereupon the petitioner's mutation application be considered and disposed of preferably within 2 months. Without any further delay, and in any case within an outer limit of 2 months from the date of completion of the digitization. The learned counsel appearing on behalf of the petitioners had submitted that the order was passed on 12/8/2025 and till date, the process of mutation of the petitioner is yet to be completed. This court have also heard Mr. R. Pujari, the learned counsel, who appears on behalf of the respondent numbers 1, 2, and 3, who submitted that though the initial process of digitization is over, but it is pending verification from the higher authorities, and as such, the digitization cannot be said to have been completed as on date. So, this court have inquired with the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3 as to what is the connection between the completion of the digitization process with the mutation application of the petitioner, more particularly when the mutation application is to be carried out, it is to be decided in terms with the provisions of the Assam Land and Revenue Regulations 1886 and the settlement rules. Further to that, for the purpose of carrying out the mutation, the requirement is as to whether there is a prima facie title as well as the possession. For the purpose of the possession, what is required is the report from the concerned officer. And such report cannot be a part of the digitization. Under such circumstances, this court does not find that the non-completion of the digitization process can be an impediment towards the mutation application, towards the consideration and disposal of the mutation application. Mr. R. Pujari, the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3, submits that the needful would be done. An update be placed before this court on 7th of October 2026.
I'm so obliged.
All right. Yes, what is this?
Contempt proceeding mila, kindly see and last order mila, order dated 22 mila, 22/6.
Have disposed of? Finished.
By order dated next page, Lordship, 37/2026.
You have a copy?
No, I am not.
Have they given you a copy?
Lordship.
This is an application Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. S.S. Roy appears on behalf of the respondent number two. The present contempt application has been filed alleging willful and deliberate violation to the order dated 28/3/2025 passed in WPC number 5161/2022, wherein the learned court net bench of this court directed that the
Yes, 10.
application so filed by the petitioner be considered by giving a reasonable opportunity of hearing to the petitioner or any other persons that may have a claim over the issue, and the entire exercise be completed within a period of 6 months from the date of filing of the application. When the matter was listed before this court on 22/6/2026, attention was drawn to this court to a communication dated 26/3/2026, wherein it was stated by the respondent number two that various steps have been taken pursuant to the application filed by the petitioner for disposal of the same, but it is on account of the petitioners having not cooperated in the proceedings, which have been registered as miscellaneous case number 38/2026. The said proceedings could not be disposed of. Under such circumstances, this court, by the order dated 22/6/2026, passed a direction to the Circle Officer Bagbor Revenue Circle to dispose of the miscellaneous case number 38/2026 on or before the next date and place a report before this court. Today, Mr. S.S. Roy, the learned counsel appearing on behalf of the respondent number two, has placed a para-wise comments in respect to the present contempt application. And further, the order dated 30/7/2026, whereby the miscellaneous case number 38/2026 was disposed of. The said instruction along with the order dated, the said instructions as well as the order dated 30/7/2026, the copies of the instruction as well as the order dated 30/7/2026 have been served upon the learned counsel for the petitioner. The said instructions so placed before this court are collectively brought on record and marked with the letter Y. Considering that the order has been passed on 30/7/2026, thereby disposing of the miscase number 38/2026, nothing further remains in the contempt application, for which the contempt proceedings stands dropped. The dropping of the present contempt proceedings, however, shall not prejudice the petitioner to assail the order dated 30/7/2026 before the appropriate forum.
No.
IA for what?
Implement for new incumbents, my lord.
Whom?
Deputy Commissioner.
Why?
My lord, earlier one is later,
What is the direction?
in my lord contempt case, my lord, to
Again, non-payment. What? NOC.
yes, my lord.
Why NOC has not been done?
It's 59 lordship direction. Here lordship, although speaking order, honorable court directed to pass a speaking order, but otherwise lordship that one letter was communicated to the petitioner, whereby his hard claim was negated.
Rejected.
Rejected lordship.
You filed an affidavit.
I am not filed with the
So and so information regarding the cause of rejection of AR. This was done on when?
It was done on lordship after the passing of the honorable court's order also. It was passed on lordship 26/8
2005 Lordship.
And this was dispatched on application bearing issuance. I have to serve up. Okay. Certified copy of the year 1997 in respect to the purchaser was not submitted along with the application. Moreover, the certified copy for the year 65 so and so was submitted in respect of purchaser, but purchaser's grandfather's name found mismatched. In the certified copy of the 65 and 70 purchaser's grandfather's name is mentioned as Abdul Sukur Mia and Abdul Sukur Mirza. In the certified copy of Iman and Surya in the voters list, for which relationship could not be established and could not be asserted. My goodness, circle officer has now taken the role of a foreigners tribunal.
Lordship.
Huh?
Lordship.
Fantastic. There was a direction of passing a speaking order. Have you
Lordship,
passed that?
That was not done. So
Why?
in the
Let's see the face of the circle officer then.
in the meantime, direction was given to the district commissioner also. He was transferred also.
No, I'm not concerned, but the
Lordship gives sometime
the
the
question is out here is, there was a direction for passing a speaking order. Why haven't you passed the speaking order?
Lordship gives sometime Lordship, the present incumbent will pass the order.
Who?
Newly incumbent Lordship, incoming. Earlier,
Earlier it was rejected. Was there a direction upon the district commissioner to pass the
No,
order, or was it to the designated authority?
no Lordship.
In the present incumbent also, I have submitted the representation.
Hmm? Where is the speaking order?
Page 59.
Page 59 is the direction Lordship.
Page 22, 21.
Two.
Is that the direction?
Paragraph 32 Lordship.
This direction.
Paragraph 32 is the direction part Lordship, page 59 Lordship.
You have not passed it.
It was earlier incumbent was just transferred Lordship. So Lordship, new incumbent will pass it Lordship. Lordship give some time, I will inform them Lordship. And recently she is joined Lordship.
Urmia. Yaton Nessa. What is your problem as regards this voters list? Mr. Counsel, have you corrected the voters list? Got it corrected? This Mia and Miza.
I have to take instruction. I have no.
Do one thing, we have it on another date. We
Yes.
don't do this. You take note of that document. In the meantime, you try to correct it.
Yes.
And after correcting, then I pass an order to take that and then decide the speaking order.
Lordship.
And if they don't do it, then yes, Mr. Dinath. Why do you say that the circle officer was the designated authority?
Land sale permission has to.
No. Declaration, it has been given notification of 11/11/2022 says designated public servant is the deputy commissioner oblique to be nominated by the deputy commissioner. Now, has the nomination of the deputy commissioner was made in respect to that particular person, the circle officer?
In that judgment, in paragraph 18,
Rejection is different.
it was by the.
See, the rejection is different from that particular person. Why the speaking order was not passed by the district?
In fact, the full court has set aside that rejection order because there was no reason.
Understood, I'm not on that. But no. Well, Mr. Counsel, kindly say. Was the designated, when was he designated the circle officer? We recall that order and then we take it up. When was the circle officer designated? No, that has not been brought in because you see, in this judgment only I could see the notification dated 11/11/2022 says that Designated public servant means the deputy commissioner oblique to be nominated by the deputy commissioner. Means the nomination has to be by way of an official document. So therefore, then that designated officer was to pass the speaking order. And this speaking order having not been passed, if it is so that there is no nomination by you in respect to the circle officer, then obviously there is a violation. What is that item number 7? 7 8 এটা আছে না? হ্যাঁ? Item number 11, দুটা বজাত আকৌ ল'ম. Ask Mr. E.K. Talukdar to appear. You show me that document. Unless you don't show me, then I'm initiating contempt against the deputy commissioner. Tell me. No, direction is different. He has to be nominated by way of a document. Be careful with this. Yes. In this case, whether the circle officer is nominated,
It was done, yes, as such, he has also given the letter also to the authority also. The concern-
rejection is different from this. So therefore, so and so. You see, sending it to the designated authority under the Assam right, what the Right to Public Service Act has become a redundant feature. Because of the fact that what you are doing is just for the sake of it, it is a very perfunctory function which is being conducted by you. You are not doing it in accordance with that act. We'll take your matter. You just produce me that document. Otherwise, it will be construed to be a violation by the deputy commissioner who will initiate disciplinary proceedings against him. I'm very serious on that aspect. But we are going to take it up at 2. You get that document of nomination. It has to be exist prior to that order of 2/2/2026. What I'm not concerned. That is a document which is an official document. That document has to be also digitally signed prior to 2/2/2026. And I will only, otherwise it is an inaction on the part of the district commission. Take it up with your Karimganj fellow. Why haven't you passed the order?
That's what I'll obtain, sir.
The order was to be passed within a period of 45 days. This person has removed only recently.
No, it did.
When did he go?
Regarding lawsuit, circle officer has,
Forget about circular officer. I'm not concerned with the circular.
circle officer has the passed.
Unless you show me that document.
Also.
Circle officer is also made a party, but you have to show me this person. When was he transferred? This Rohan Jha?
Recently, he was transferred recently.
Then it is a violation by him. We make the new person also a party and we hold the Rohan Jha also accountable for non-compliance. We immediately hold him. I'll hold him to be there's a misconduct on his part and initiate disciplinary action against him. And as regards the other one, we take it up. This is an application filed for willful and deliberate violation to the order dated 26/8/2025, passed in WPC number 2361/2025, whereby the learned coordinate bench of this court passed the following directions at paragraph number 32, which is reproduced here in under. From a perusal of the above quoted paragraph, it is seen that there was a direction upon the designated public servant to dispose of the petitioner's application by passing a speaking and reasoned order within a period of 45 days from the date of submission of a copy of the order by the petitioners before the designated public servant. The copy of the order was served upon the District Commissioner Borpeta on 3/10/2025. However, till date, there is no order passed. This court also takes note of an interlocutory application which has been filed, wherein by an order passed today, this court have impleaded the present incumbent District Commissioner of the Borpeta. Full stop. It is an admitted fact. There is no quarrel with the fact that till date there is no passing of any speaking order. And it is only recently that a respondent number 1 had been transferred. Under such circumstances, the respondent number 1 conduct for not complying with the directions within a period of 45 days from the date of submission of the certified copy prima facie appears to be contemptuous. This court further takes note of that there are two aspects of the matter. First is a misconduct committed by the officer in not complying with the directions passed by this court. And the second is a question of punishment. First, this court, therefore, the non-passing of a speaking order by the respondent number 1, as well as the respondent number 1, who is the designated public servant, amounts to a misconduct within the meaning of the Assam Assam Services Discipline and Appeal Rules 1964. At a later stage of the present proceedings, this court shall pass appropriate orders on this aspect. The second is as regards initiation of contempt. Accordingly, this court grants an opportunity to the respondent number 1 to show cause by filing an affidavit as to why contempt proceedings should not be initiated against the respondent number 1 for non-compliance of the order dated 26/8/2025 and accordingly punished. The affidavit on behalf of the respondent number 1 be filed on or before 16th of September 2026. List this matter on 23rd of September 2026. Issue notice upon the newly impleaded respondent number 3. Steps be taken by way of speed post. In addition to that, the petitioner is granted the liberty to take steps by way of dusty upon the newly impleaded respondent number 3 and file an affidavit of service on or before the next date. The respondent number 3 shall apprise this court as to as to whether the order dated 26/8/2025 passed in so and so have been complied with from his end. First, in addition to that, the respondent number 2 shall also file an affidavit as to whether the order dated 26/8/2025 passed in so and so have been complied with from his end.
But with the designated authority, just we have searched it, Lordship. Circle officer was designated.
Let him initiate.
Lordship.
Circle officer cannot be the designated authority unless there is a nomination.
Nomination part is there for you, Lordship. That is
Show me that
Lordship, I'll place it, Lordship. I'll place it.
paper as to why contempt proceedings should not be initiated. Then I will put it on the petition number 2, response number 2.
Circle officer, Lordship.
He will go.
That's why he has passed the letter. That letter also issued.
No, letter would not do. There's a direction for speaking.
Speaking.
No, it's okay. Economic party banai dibo. Response number 3. I allowed. You file a fresh memo of parties in this contempt petition. It order to the dibo.
May I please, Lordship?
Yes, contempt, what is this?
For implement of new incumbent Lordship in place.
Huh?
For implement
What
of
is the
new incumbent.
contempt
Lordship.
for? You will see, implement will go on.
Former respondent number 1 has been transferred, Lordship, from Hailakandi district.
Hardly matters. What is the direction?
Direction is, Lordship.
Given the facts in which this IA has been prepared, the respondents are directed not to interfere with the possession of the petitioner on the land at so and so. This is the order.
Yes, Lordship.
Who interfered?
Lordship, violating this order, Lordship, authority, Lordship, started work, Lordship, and demolished some houses, Lordship, and
Who interfered?
Lordship, from the Lordship, 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 Executive Engineer, Hailakandi Water Resource Department, Lordship. Executive Engineer, Hailakandi Water Resource Department, Lordship.
So he interfered.
Lordship.
Others did not. 1 and 2, 3.
Yes, Lordship. They are also Lordship, part of this, Lordship.
Then why do you, once it has been interfered with, once somebody had demolished it, why do you need the press incumbent? He has not done anything.
Lordship, in place of.
Don't make the press incumbent a party if somebody has already contempt. You see, this is not a continuing contempt. The contempt has already happened on a particular date. The direction was directed not to interfere with the possession of the petitioner in the lands of so and so without the leave of the court. Okay, so you say out here in your contempt application, then when on 5/3 men of the respondent number 2 started dumping the earth by demolishing betel nut trees. Okay? So it is the respondent number 2. Why you are making respondent number 1 and 3 a party?
Lordship, but direction was, Lordship.
Mr. Counsel, you have to understand. If I direct A, he has to, contempt is not is a quasi-criminal proceedings. Isn't it? So one, it is a quasi-criminal proceedings. It is a case against a particular individual. Isn't it? If it is so, there has to be an allegation in your contempt petition. Is there any allegation against the respondent number 1 and 3?
Lordship, they filed their.
Mr. Counsel, answer to the point. Whether there is any allegation against 1 and 3.
Impliedly, Lordship.
No, impliedly in cloud 9 when I will think about. Now come to the point. Is there any allegation in your petition against respondent number 1 and 3? No. So we strike out. Now whom are you trying to make a party? Whom? Whom do you want to make a party now?
Executive Engineer.
Why?
And,
Why? Why you are making the DC a party in these proceedings? Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. D. Nath appears on behalf of the respondent numbers 1 and 3. Who appears for number 2? You appear for number 2. You have filed your affidavit. The present application has been filed alleging willful and deliberate violation to the order dated 3/12/2025 passed in IA Civil 3925/2025 in WPC number 6639/2025. In the said order dated 3/9/2025, 3/12/2025, the learned coordinate bench of this court directed the respondents not to interfere with the possession of the petitioners on the land covered by periodic patta number 68, dag number 244, patta number 5 of dag number 33, 67, 68, 70, patta number 68, dag number 231 and 233, and patta number 38 and 39, and of dag number 110, 111 of village Bondukmara under Moza Bondukmara in Hailagandi district without the leave of the court. The allegations so made in the instant application can be seen at paragraph number 4, wherein the allegation is only against the respondent number 2. There is no allegation as qua the respondent numbers 1 and 3. Under such circumstances, the question of issuance of notice qua the respondent number 1 and 3 does not arise. Accordingly, the respondent number 1 and 3 are struck, names of the respondent number 1 and 3 are struck off from the array of parties in the present proceedings. The learned counsel appearing on behalf of the petitioners has submitted a fresh memo of parties before the registry of this court within 3 days. Wherein only the respondent number 2's name, wherein the respondent struck off, full stop. Accordingly, the respondent number 2 in the present proceeding is renumbered as the sole respondent. The learned counsel appearing on the behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 3 days, and the registry on the basis of the present order, as well as the memo of parties, make necessary correction in the cause title and update the same in the CIS. Ms. Ardeka submits that an affidavit has been filed by the respondent number 2 denying to such allegations. You have filed reply?
Reply file lordship. They have filed lordship reply.
You have filed reply? The counsel appearing on behalf of the petitioner submits that he would like to file a reply. Accordingly, list this matter on 25th of September 2026. IA Contempt. The instant application has been filed by the petitioner to implead the present deputy commissioner as an incumbent, as the respondent to the present to the accompanying contempt application. A perusal of the said application shows that the present incumbent deputy commissioner is sought to be, district commissioner is sought to be arrayed in the contempt applications only on the ground that he is the district commissioner of Hailakandi. There's not a single allegation that the district commissioner, the present incumbent district commissioner, is anywhere involved in violation of the order dated so-and-so, passed in so, I number so-and-so, arising out of so-and-so. Considering the above, the instant application is misconceived for which the same stands rejected. Dismissed.
This case was dismissed for default.
Why?
So not, I was absent, my lord,
Why?
due to out of station due to the death of my mother-in-law.
And what is this IA for?
Pay about disposition of the case.
IA for what?
134.
Huh? Section 5. No objection.
I will file an objection.
Why? Hey, this is his fault. Lawyer's fault. What do you do?
As per the instructions, Your Lord.
What is the matter about?
It was,
It is a matter of paying for directing, commanding the response authorities to immediately pay compensation to the petitioners for acquisition of their plot of land measuring 1 bigger 10 lessons covered by Dagnang 9 Patanang.
What appeal has been filed?
My lord, I have already filed affidavit in reply. They have also filed affidavit.
Is the appeal you have filed? 22/4/2016, an appeal has been filed before whom?
Before circle.
You are PDCL?
yes,
It is.
actually, I am not aware of the whole fact.
Not necessary. Get hold of a proper PDCL counsel. Are you
No, I'm for the
Get
responding
hold of
for
it.
6.
We allow this type of application and this will go as per that standard of Works Act or Work Exercise Act. If there is a compensation, then it will be going as per section 15 of that rules. Get hold of a PDCL counsel, dispose it of. Allow this, dispose of. No, not yet. Wait. You are a PDCL counsel. Yes, come in. You have this, some work rules, no? What is that?
I have to check once.
You are also not there. Ask Mr. B. Chaudhary or KP Pathak or B. Das.
I'm appearing on behalf of KP Pathak, but he's on legs, therefore.
Ask anybody,
That's,
any three of them to appear.
that's,
We pass that order and allow this type of, these are small matters you need not detain this court. What is there? We should not fight. You see, he has a problem with your mother-in-law or mother,
Mother-in-law.
and he has to go.
no, we have no objections. The principal respondent was
Who is
respondent
the
3.
principal respondent?
Respondent R3 minutes, AGCL.
GCL, this will be, who has occupied the land?
AGCL minutes. AGCL.
APDCL.
Lots.
AGCL have taken the land.
Yes, my lord, yes.
Huh? Who has taken the land? AEGCL. AEGCL's counsel is who?
I'm appearing.
Yes. How are you regulated? Means when you, unless is it the public this is done under the Electricity Act.
Yes, Your Lord.
So that rules would not apply.
We apply, Your
That what is the name of the rule?
Lord. Assam electricity.
No. So Assam works earlier, some works rules or something. What's the name? License rules something, 15, clause 15. I've passed many orders on that. Ask Mr. B. Chaudhary. I think if it is applied, then it is that authority.
Yes.
That it will be looked into by the district commissioner as to whether the land has been taken, whether it can be first done through amicable settlement. If it is not done, the district commissioner will value the area. After the district commissioner looks into if the person is aggrieved by that, then they can go to the appropriate commission.
Yes.
Appropriate commission will be the AERC.
Yes, AERC.
So this is how the mandate is. I think the standards of works rules, 90 exercise rules or something. Anyway, you find it out. We'll dispose, pass that order and dispose it off. And I don't think you should have any objection as regards the condoning and all.
No.
এখন দিব, interlocutory application খন দিব. In the meantime, get hold me that rules. পাইছে নেকি এইটো? License rules খন যে আছে. আচ্ছা, earlier, huh? That one. 2019. Yes, this one. Kindly come to 15. 15 left. Yes, determination of dispute or difference, just go to 13. Where the licensee makes default in complying with any of the provision of these rules, he shall make full compensation for any loss or damage incurred by the reason thereof to the person affected, as may be determined by the district magistrate or by the parties concerned. Where the difference and dispute arises as to the amount of compensation determined under sub-rule 1, the matter shall be determined by the appropriate commission. Then 15, it will be done. So this is the way how you need to solve it out. Okay. Wait, don't move. We allow his questions. Your name?
Das, Arvind Das.
Ada, the learned counsel appearing on behalf of the applicant. In IAC number 2801 applicant, icon 2801/2020, along with Ms. K. Pupon appears on behalf of the respondent number 3. Who is respondent number 6? The respondent number 6. So and so appears for the respondent number 6. And other they can Assam State Electricity Board, that is no longer there. My goodness, who can help you? So and so appears for the respondent number 2. And Mr. N. Das appears on behalf of the respondent number 4 and 5, opposite party. This is an application for condonation of delay of 134 days in preferring the accompanying application for restoration of the writ petition which was dismissed for default. Taking into account the reasons which have been cited in the instant application and there being no objection on the part of the other respondents, this court allows the instant application, thereby condoning the delay of 134 days in preferring the accompanying application, being Miss Case number 59/2026. Miss Case 59 is an application for restoration of the writ petition for restoration which was dismissed for default by the learned coordinate bench of this court by an order dated 10/2026 passed in. By an order dated 10/2026 passed in WPC number 1 in the accompanying writ petition. The court have duly taken note the reasons which have been assigned in the instant application and is satisfied that the petitioner had a good cause in not appearing before this court on that day on 10/2026, and accordingly this court restores the writ petition to the file of this court. I stands allowed. This case stands allowed. Now writ petition condemn. This is an application for, we do one thing. Allowed. A WPC number 1766/2026. List this matter again. Well, in view of the order passed in, I number so and so and Miss Case number so and so, the instant writ petition is restored to the file of this court. List this matter again. When you will be available?
Yes.
The mother-in-law is better now.
No, yes, brother-in-law. Dead.
Mother-in-law changed to brother-in-law. Anyways, we do one thing. We'll finish it off on 24th of August for admission.
On which date, my lord?
24th of August.
Lovely.
4. On that day, we'll pass that order because otherwise the problem is this order, this writ petition has to be restored. It is otherwise shown as dismissed. This item. SP Das, what is this?
Maybe the lordship. The petition number 1 and 2 are husband and wife, my lord. Their bank account has been kept on hold, my lord, since 2024.
Why?
But a fraud was committed and an affair was lodged, my lord.
Who has committed the fraud?
Not me, my lord. Not me, my lord. But there is a standard of procedure which is governed by this rule, my lord. If a lordship comes to that annexure 9, this is the standard operating procedure to deal with such cyber crimes, my lord. In my case, my lord, no notice was ever served to me, my lord. Neither the complaint. And lordship may kindly come to page number 90. That starts from page 89. Grievance redressal mechanism.
What do you say about this amount? Total is, they have put it on affidavit. The account numbers, Hemantodas, 1,50,000, 1,500 and 1,35,000.
Yes, ma'am.
These are disputed amounts?
Yes, ma'am.
Okay, we allow this to allow it by keeping this on hold. And in the meantime, the bank managers, who is there for HDFC? Or all are State Bank?
No balance. 1, 2 and 5 State Bank and HDFC one was response number 4. Yeah.
So the bank managers of these banks will report it to the GRM. It's the matter before the GRM.
My grievance is that my amount of rupees 1.5 lakh each has been kept on hold since 2024, my lord. That is my grievance, my lord.
No, my question is, there is a dispute pertaining to 1,50,000, 1,35,000.
Yes, ma'am.
1,500.
Yes, ma'am. Yes, ma'am.
So this is a disputed amount.
Disputed amount, my lord.
There are two options.
Madam.
I can allow you to go to the GRM, file an application, and immediately it will be reported to the GRM, and within 90 days it will be done.
Yes, ma'am.
You want to go by that
Yes, ma'am.
SOP?
Yes, ma'am. SOP, my lord. Yes, ma'am. Yes, ma'am.
Heard Mr. S.P. Das, the learning counsel, appearing on behalf of the petitioners. Mr. A.K. Sahewala, the learned counsel, who appears on behalf of the respondent number 1,
2 and 5 minutes.
2 and 5. And Mr. M. Smith, who appears on behalf of the respondent number 3 and 4. The case of the petitioners herein is that the petitioners have invested in DB stock brokering through the respondent number 11. On account of certain incentives being provided by the respondent number 11. It is the further case of the petitioners that the petitioners invested an amount of around 7 lakhs in the DB stock brokering from December 2013. And everything was functioning smoothly. However, on 16/11/2024, Sri Vaibhav Ramteke had lodged a complaint before the respondent number 6, stating that a cybercrime had been committed against him by DB stock brokering. Pursuant thereto, it is the case of the petitioner that an amount of 4.5 lakhs in the separate accounts of the petitioner in total have been put on hold. It may not be out of place to mention that the petitioner, number 1, has 2 accounts. One is with the respondent number 1 and the other is with the respondent number 3. 3, no?
3 and 4.
3. Whereas the petitioner number 2 has an account with the respondent number 1. The details of the account of the petitioner number 1 are A to page 8 of Pabhan. A and B whole, petition number 1 and C whole, and A to the details of the petitioner's number 2's account is A to SBI account number so and so. Arpita Dev will likhibo nalage. On account of the petitioner's bank account being frozen, na?
No, but kept on hold.
As a petitioner, what is that hold?
Hold is a particular amount.
On account of the petitioner's bank, on account of holding of 4.5 lakhs of the amount
Total.
on hold in the separate accounts of the petitioners. The petitioner has approached this court by filing the writ petition. The records reveal that this court, by an order dated 10/6/2026, issued notice. An affidavit has been filed by the respondent number 1, 2, and 5. Wherein it is stated that a complaint was lodged before the Cyber Fraud Reporting and Management System, wherein it was reflected that the account number 2024-845 5684 and of the petitioner number 1 and the account number 2000-621-08582 of the petitioner number 2 were having credit of disputed amounts. The details have been provided in the form of a table, which is reproduced here in under. It was further mentioned that in view of the above, an amount of rupees 1,51,500 have been marked as a lien in the petitioner number 1's account, and an amount of rupees 1,35,000 have been marked as a lien in the petitioner number 2's account. Mr. Smith, you have filed your affidavit? No. Mr. M. Smith, the learned counsel who represents the respondent number 3 and 4 submits that on the basis of the Cyber Fraud Reporting and Management System, an amount of rupees 1,50,000 have been marked as disputed in the petitioner number 1's account maintained in the respondent number 4's, the respondent number 3 bank. The respondent number HDFC is 3. 4 is the branch. What is the branch? The bank, if we say it is HDFC, na? In the account held with the respondent number 4. This court finds it very relevant that to take note of that the Ministry of Home have issued a standard operating procedure for bracket NCRP bracket close dash CFC FRMS bracket close custody, restoration of money and grievous redressal on 2nd of January 2026. Chapter 3 of the said SOP provides the grievance redressal mechanism. There is also a time limit within which such grievance can be settled. And more particularly when it is the claim of the petitioner that the disputed amounts, the amounts which have been disputed, are the entitlement of the petitioner, isn't it? Yes, ma'am. Considering the above, this court therefore disposes of the instant petition, thereby directing the petitioner, thereby granting liberty to the petitioners to approach the respective branch managers of the petitioner's bank placing a complaint against the marking of lien in the petitioner's accounts, in the petitioner's respective accounts. It is further observed that in terms with that upon such complaint being submitted, the branch managers of the petitioner's bank shall initiate the procedures in terms with the SOP dated so and so. It is further directed and observed that the further proceedings shall be conducted in the manner stipulated in section 3 of the Roman 3 of the SOP.
My lord, some time bound, my lord.
90 days it is given.
Lordship may record that.
No, I need not. Why should I have another date thing? It is already said that within 10 days this will happen, 10 days this will happen. I don't know, you have enclosed the recent one.
I'm recent, madam.
Then it is categorically given. I have read it.
Yes, madam, read. I'm obliged, madam.
Well, I have spoken to the DC, Malad. There is a letter, Malad, but he is not in office. He is in connection with some office work. I have spoken to the DC, Malad. In connection with some office work, he is outside. He'll be coming in the office in the second of Malad, around 3:30. Can it be taken tomorrow at 10:30? I'll place it.
You take it up on some other day. This order I'm not passing it today.
Lordship.
I'm not closing it.
Lordship.
This I have otherwise closed it.
No.
But I won't.
Malad.
Friday. This is the matter on Friday.
Lordship.
On which date Mr. Dinath, the learned counsel appearing on behalf of the respondent number 1 and 2 shall produce the notification by which the circle officer have been designated as the designated public servant in terms with the notification dated 11/10/2022.
This is 11/11/22.
This matter, the petitioner is instructed us to withdraw your.
Withdraw. Yes, ma'am. And the counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant petition. Accordingly, the petition stands closed on withdrawal. Interim orders heated. Who is the other side?
Other side.
Tender of which department? We go away. PWD.
PWD is there.
Yes, you are PWD. In time order stands vacated.
Before my learned friend starts, Lordship may kindly take up this matter day after tomorrow, Lordship. I had a talk with the ADC, Kasar Silsor, they are going to provide me the instructions, Lordship.
Have it on Monday. Request of Mr. H. Sharma, the learned additional senior government advocate, the matter stands adjourned to be listed on Monday. Monday, date to deliver at 2 p.m. for final disposal.
Lordship. Monday on 24, Lordship. Lordship.
May I please, Your Lordship? Is appeal against the award
What is the ground of appeal?
my first ground of appeal is under sections 166 of MB Act, the burden lies on the claimant to prove rash and negligent drive, my lord. Here the claim petition is made under section 66, my lord.
Yes,
May I allow to read the judgment, my lord?
read it. Huh? Read it. Now tell me, what is your case?
My lord, the first, truly speaking, my lord, there is no much ground for appeal, my lord. First is one under section 166 of MB Act, the burden lies on the claimant to prove rash and negligent drive. The claim petition has been filed under section 166, my lord. For that, I have a judgment, my lord.
No, it's okay. There was PW1 and PW2.
Two, my lord.
PW1 had filed an FI, he was not present, but the PW2 was there.
Yes, my lord.
And he had categorically said that he has seen the Maruti car coming from the behind and then banging this father of
Yes,
the
my lord. Yes, my
PW1. And then he died.
Yes,
It is automatic that there is a rational negligent
Yes,
driving.
yes.
You
Yes,
can't
madam.
keep, drive a vehicle, hit somebody and then come up and say that where is the rational negligence?
Yes, my lord. Yes, my lord.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent numbers.
Respondent number 1.
Respondent number 1. The present appeal is directed against the judgment and award dated 3/7/2013 passed in MSC case number 22634/2007, whereby the learned Motor Accidents Claims Tribunal Kamrup at Gauhati had awarded an amount of rupees 8,12,000 as the compensation payable by the appellant by the owner of the vehicle bearing registration number AS 25B2848 along with interest at the rate of 6% from the date of filing of the claim petition, that is 4/2/2007, till payment. The sole ground on which the appeal has been preferred by the appellant is that the learned tribunal erred in law in deciding the issue number 1 without there being adequate proof that there was rash and negligent driving on the part of the driver of the offending vehicle. The learned counsel appearing on behalf of the petitioner further has submitted that in the case which falls within the ambit of Section 166 of the Motor Vehicles Act 1988, for short the Act of the 1988, it is the burden upon the claimant to prove that there was rash and negligent driving. Taking into account the said ground, let this court now analyze the impugned judgment and award along with the records of the learned tribunal. Here the respondent number 1 is the daughter. Who died?
The father died. Kalia Soikia.
Kalia
Kalia
Soikia.
One Kolia Soikia, since deceased. While walking towards Pothor Quarry Tientiniali, was hit from the backside by a vehicle bearing registration number AS25B1848, which is owned by the appellant. The said Kolia Soikia, on account of the injuries suffered, succumb to the injuries and expired on 22/10/2007 in the GNRC hospital. The daughter of the wife, the wife of late Kolia Soikia as claimant initiated a claim proceedings before the Motor Accidents Claims Tribunal, Kamrup at Gauhati, which was registered and numbered as MAC case number 2634/07. Under section 166 of the Act of 1988, claiming an amount of rupees 15 lakhs as compensation. The appellant, who was the opposite party number 1, submitted a written statement wherein he stated at paragraph number 6 of the said written statement that while he was driving on 18/10/2007 along at around 11 a.m., the Maruti vehicle along the express highway with his 2 companions, he saw a motorcycle entering from the left side feeder PWD road, and the claimant's husband was riding a bicycle on the wrong lane and got puzzled with the motorcycle, and as a result lost his balance and fell down on the road. He further stated in his written statement that at the request of some persons from the gathering on humanitarian ground, the appellant boarded the injured person in his car with the help of a few persons from the gathering, and the 2 persons and the injured was shifted to the GMC hospital Gauhati, wherein he was admitted in the hospital. After some time, the son of the injured, Sri Deepak Soikia, reached the hospital along with Sri Mohan Mohanto, and after briefing the condition of the injured person, the appellant and his companion left the hospital. He further stated in his written statement that he possessed a valid driving license bearing DL number 3452/NB/2002/PVT, which was valid up to 25/8/2012. A further perusal of the written statement shows that the appellant denied involvement of any involvement in the accident. On the basis of the issues so formulated on the basis of the pleadings, two issues were formulated, which were number one, whether the victim, late Kolia Soikia, died as a result of the injuries sustained by him in the alleged road accident dated 18/10/2007, involving the vehicle number AS25B/1848 Maruti car, and whether the said accident took place due to the rash and negligent driving of the driver of the offending vehicle, ? Number two, whether the claimant is entitled to receive any compensation, and if yes, to what extent and by whom amongst the opposite parties the said compensation amount would be payable, ? On behalf of the claimant, only one witness, na?
Two witnesses are there.
On behalf of the claimant, two witnesses adduce evidence. The PW1 was the claimant herself. To her, in her, so while adducing her evidence, she had adduced, so she had exhibited the accident information report, certified copy of the postmortem report, salary certificate, medical expenditure of the GNRC, and the death certificate. In the said proceedings, this court duly takes note of the postmortem report which have been enclosed to, which have been exhibited as Exhibit 2. The cause of death mentioned in the postmortem report was as hereindunder. Cause of death was coma as a result of head injury sustained, full stop. All the injuries were ante-mortem, comma, caused by a blunt impact and consistent with vehicular incident. Inverted comma close. This court finds it relevant to take note of that while cross-examining the PW1, no question have been put on the aspect pertaining to the cause of death as recorded in the postmortem. This aspect is relevant, taking into account the stand which was taken by the appellant in the written statement. Further to that, Exhibit 1 is the report about the motor vehicle accident. Prepared on 18/11/2007. Wherein it was mentioned that the driving license number of the appellant, expired on 31/1/2005. And the insurance to the said vehicle also expired on 10/1/2001. The vehicle number was also mentioned as mentioned to be the vehicle belonging to the appellant. Criminal proceedings which were this court also finds it relevant to observe that upon the FIR being filed, a charge sheet was upon being FIR being filed, a case was registered as Nunmati PS case number 236/67 under section 279/388. The said a charge sheet was submitted in respect to the Nunmati PS case number 236/ I think 67 or 07. And it was converted into GR case number 5670/07. Evidence which was adduced in those criminal proceedings were also exhibited before the learned Motor Accidents Claims Tribunal. What is this fellow's name? Wherein one Sri Vikas Kaklari, huh?
Yes. PW2.
who was the PW2 in the said criminal proceedings, had adduced evidence to the effect that he saw the vehicle of the appellant hitting late Kolia Soikia from behind. So, on the basis of these evidence, the learned tribunal, while deciding the issue number 1, came to a categorical finding that the vehicle being registered as AS25B 2848 was involved in the road accident dated 18/1/2007 and was driven in a rash and a negligent manner. Resulting into the accident which led to the death of late Kolia Soikia. This court is of the opinion, having perused the materials on record, as well as the opinion rendered by the learned tribunal as regards the issue number 1, do not find any perversity or any error calling for interference by this court in exercise of the appellate jurisdiction. This court further takes note of that the learned tribunal, while deciding the issue number 2, came to a finding that the claimant was entitled to an amount of rupees 8,12,000 Should we increase it?
No.
Huh? Because in view of pronouncity, we should increase it. Don't you think so?
Alright, half had already been paid. No,
What?
half had been paid during the pendency of the appeal.
Amount of rupees 8,12,000. This court does not find any infirmity in the said method of determination of the compensation. The interest also which was awarded also appears to be reasonable. Next. Consequently, there appears to be no ground for interference with the impugned judgment and award dated so-and-so, passed in so-and-so. Accordingly, the instant appeal stands dismissed with the following observations and directions. The impugned judgment and award dated so-and-so, passed in so-and-so calls for no interference. Number 2. Yeah, I guess so. It is also noticed that out of the awarded amount of rupees 8,12,000, along with interest at the rate of 6% from
4/12/2007.
so and so. An amount of rupees 4,06,000 have been deposited, which was received by the petitioner claimant. The remaining amount with interest calculated till date after deducting the amount which have been paid the amount of compensation along with interest calculated till date after deducting the amount which have already been paid be deposited by the appellant before the where?
Before the tribunal?
Which one? Because at that time it was coming.
It was not.
Where? Before the Motor Accidents Claims Tribunal. Number 1, Kamrup Metro at Gauhati. Within a period of 2 months, 2 months from today, the records be forthwith returned to the so and so. The court to hear to the trial court to the so and so.
One.
Kamrup. Motor Accidents Claims Tribunal number 1, Kamrup Metro at Gauhati. Yes, where is Mr. You are too busy with your work. Yes.
I was going through the instructions.
Same.
Lordship, now the details regarding this work has also been submitted.
Hey, what is the other matter?
319, contempt case 399 of 2019, Lordship.
One exco issue. Huh? 399/2019 19 যোনটো order আছে exactly হেতু pass কৰি সেইদিনে একেলগে fix
May to the
Yes.
the interlocutory application 867 has been filed by me. My lord, the order that was passed by the Lord single judge against, my lord, if your lordship kindly turn to page
Is
9.
the interlocutor who has filed this?
I has been filed by me.
my senior friend.
You have filed. What is the case about?
My lord, your lordship may just turn to page 99 of the IA.
No.
That was the impugn order passed under 3G compensation was decided. Then they file an objection to the competent authority, and the competent authority, after giving both the
that in respect to compensation for Jirat pertaining to Bharatmala project, in past where one part of the government has been used to the private respondent and the other part has been directed to the. I can
they filed a title suit, my lord, title suit was pending. During pendency of the title suit, they jumped over here and they got a stay order. And my building has been demolished, place has been taken over. I am on the, without getting any amount. That 50% which was decided to me, now they have filed a suit previously to the writ petition claiming right title interest. Before the competent authority, no documents were placed by them. They were giving.
Where is Mr. Arbor Pujari? Ask him. Now, you see, this acquisition is made under what?
National Highway Authority.
Bharatmala project, my lord.
Which one? Either of you come to our.
My lord, this is under the National Highway Authority Act.
Bharatmala would not come in.
Not, this is National Highway.
Then why you are not both going to 3H4?
My lord, 3H4 only when the title is decided that they are also having a title. They don't have a title. They find a suit for right title interest. And my lord, they have not been able to place any document before the competent authority. Apportionment will come only when the title is, my lord, it is absolutely clear that both of us have a title. They don't have any document. They have filed a right title in their writ petition, my lord. Your lordship may turn to the plaint. Your lordship will find that they have asked for right title interest without challenging our sale deed also. I don't know how it is maintainable. Section 34 will come. They have not challenged our sale deed, anything of that sort. We have purchased through our sale deed. After 3C was over, 3D, E, F, everything was over. When 3G amount was competent authority has decided.
Does the name of their.
Nothing was there.
In 3D?
No, my lord, no, nothing.
But they are making a claim.
Claim to the amount. They are making a claim on the basis of a title suit is pending on a right title interest. And before the competent authority, no documents.
No, whatever may be, I think 3H4 will come in.
Well, 3H4 apportionment, the competent authority has already decided because we are in possession of the building, 50% will be paid to us and the 50% will be before the district judge. He will decide it for the apportionment. That was the impugn order, right? It has said, the competent authority, that 50% will be apportionment. It has said that way, my lord. My lord, that 50.
Where's the impugn order?
Page 99 in the IA, my lord.
No, where's the impugn? Has he challenged that impugn order?
That order he has challenged, my lord.
Where's that? In
Page 99 in the IA.
In the writ petition.
In the same order, my lord, same order.
Same order, where is it?
Page 56, my lord, Annex 12.
Where?
Page 56, my lord.
Same order, my lord. This is the same order which I have annexed at page 99.
Why should I look into your petition?
My lord, page 56.
It has been submitted that one title suit pertains to the scheduled land has been going on the and various of the extension of the right of possession beyond the limit. Both the parties are claiming for both land and Jirat compensation. And the second party could produce relevant documents as a possession over the land, and first party is not in a position to serve. Whereas the name of the second party is given the 3G award. Whereas it is in urgent so and so. They are also directed to vacate the land and remaining the month as per fantastic order. Why should we interfere?
My lord, what has happened, my lord? Of late, my lord, I received the instruction, my lord, that the land, my lord, which is the particular dispute arising, is a land measuring, my lord, 1 bigha, 17 katha, 6 sotok and 9 gondas, my lord, as per the measurement. And out of which, my lord, the 15 katha, my lord, had already been sold to my senior friends, my lord, client, my lord. Now, my lord, to that aspect, we do not have.
You got 50%.
My
Yes,
lord,
yes,
now this order has.
Have you got 50%?
No, my lord.
No.
There is a stay order of this order.
No. Stay order is
50% has
not
been not been given to you.
No, my lord.
Now, what is this? Remaining entire land
Mar-
compensation of 50% of the Jirat compensation will be deposited in here. Hence, 50% of the area may be paid to the Abdul Matif and others so as to enable him to shift.
This 50% will be paid to me as per the direction and the balance 50% as per 3H4. That is the direction given. my lord. And they have come over here for a stay order and that 50% has not been given to me. My house have been.
How much is your entitlement?
My lord, actually what has happened, my lord, our land, my lord, that remaining portion of land, my lord, 1 bigha, 5 katha
My lord, though it appears in paper, my lord, that it had not been acquired, but physically the land had been acquired by the National Highway Authority of India, my lord. That is the problem, my lord.
That is not.
Now,
the
my lord,
problem.
we are
That
not
is-
claiming.
These are different proceedings.
My lord,
That is not for the writ proceeding. I'm
My
not on here. Now, if you are challenging this order,
my lord.
how much is your entitlement?
My lord, the entitlement, my lord,
Out of the 100.
my lord, until and unless this civil dispute is, my lord, decided,
Mr.
My lord.
That civil dispute has no relevance
my lord.
because of the fact civil dispute will only come in respect to when the power has been given under 3H4 for the court to decide.
My lord, my lord.
So there is no quarrel. In fact, the title can also be decided in under 3H4.
My lord.
What Mr. Roy Chaudhary submits, I don't agree to what his submission is. More particularly in view of the recent judgment of the Supreme Court.
My lord.
So I don't agree to all these submissions.
No, my lord,
No.
my lord.
So therefore,
My lord.
and what about the remaining 50? How much you are entitled out of 100?
My lord, that has not yet been decided, my lord, because
That
my
has been
land,
decided 50% he will give.
50% is share and 50%.
Okay, you do one thing. You take the 50%.
My lord, and remaining.
Give an indemnity. And remaining 50 will be decided
By
in the
3H4.
3H4.
My lord.
Not that much is there.
My
That
lord.
much is my case, man. This order is only
My
that much, man. Because
So-
the impugn order itself says.
So
50%.
for me to pass that order, both of you have to interchange the area.
Malad? Malad. Who will interchange? As per your officer. Who will interchange? Malad.
My lord, only thing is that, my lord, if our land has not been acquired, my lord, by the notification.
No.
My lord.
Land has been acquired because it is categorically mentioned in the impure order.
Impugn order, my lord, that's the.
Whereas is enlisted in the 3G.
Yes,
award.
yes, my lord.
Now, where's the 3D?
Malad.
3D notification.
3D notification. It is there, writ petition, Malad.
No,
No, in your IA.
I,
Malad, in my IA, Malad.
their land has been acquired, my lord.
Malad. That I have, that 3D notification.
Notification to the premier logo.
It's not there.
Mr. Borpuzari, what is this Bharat Mala? Assam Mala I have heard. What is this Bharat Mala?
National highway, no?
Huh?
Acquiring of land for the purpose of construction of national highway. Pan India project.
But how do you do it? Who is the competent authority here? District Commissioner, Kachar, Land Acquisition Branch, Additional District Commissioner. Yeah.
This is the.
Whether the 3D notification has been issued.
From that, page 56.
Whereas, my lord.
My friend is suggesting because 3G notification, 3G has been decided, so 3D has come. Yes.
No, there is a big problem that they have found out another problem. 3G is different,
Declaration of
3D is
acquisition.
different.
For declaration of acquisition, there should be a notification.
No, the acquisition will only happen with a 3D.
That is my 3D, declaration of acquisition.
Where is that?
It is no matter. That.
Notification, my lord, we have
That
also searched, my lord. My client, I have also instructed him to give me the copy of the. But
No,
it is
the
not
central government
available.
will,
They can
either,
produce it, my lord.
either Kala will produce it or
Hello.
the central government will produce it because it's a central government
This
notification.
notification is not available.
3D is issued by the central government. Indeed.
First in, so far as Assam Mala project is concerned, which appears to be parameteria with Bharatmala project. Now, Assam Mala, lands are acquired with through negotiation, process of negotiation. Meaning thereby, my lord, it would finally, at the end of the day, it will culminate into a consent award.
Therefore, my problem out here is this. It is done under what you call the Assam Mala, Bharat Mala. Is it required for having a consent? if there is a question of consent, then if there is a dispute, which that is why I called you. I've taken up in another case, I've issued notice for the Assam Mala. Now, if there is a dispute and if it is on the basis of consensus, it cannot be an award.
Because there, if at all, my lord, the negotiation is finalized, then my lord, an agreement is executed between the landowner and the authorities. And my lord, the quantum of compensation is incorporated in such agreement. So
Because they cannot challenge it.
they cannot challenge it.
And there cannot be a Bharatmala or a particular land which does not belong to that person.
Yes. So there, if matlab per se, if it is simpliciter acquisition of land for Assam Malab, then there has to be consensus ad idem. That is matlab, the final law. If there is no consensus ad idem, then of course matlab, authorities will have to take recourse to the land acquisition law, regular proceedings. If it
So
is
then, you see, then they can't go under 3G5.
no, yes.
So they have to only stick to 3H4. The 3H4 cannot arise in a
Your lordship will
Bharatmala.
look into this notification.
Show me.
I think, my lord, it's what my friend has.
No, 3G, 3D.
3D.
Ah. Yes. Where is your name? What is your name?
My lord, next page, serial number,
We are in respect to that number.
my lord, at serial number 230, right hand side. Ghulam Hussain and others. My lord.
So Ghulam Hussain.
Ghulam Hussain. No, my lord. Our name, Ghulam Hussain is my father's name.
And
And my lord, then another one,
how many respondents are there?
Lord, 6 and 7.
The fight is between whom?
my lord, Ghulam Hussain, your lordship will find in my IA.
Abdul Matlib and Abdul Sukur.
Matlib Lashkar is the son of Ghulam Hussain Lashkar.
Abdul Sukur.
And Abdul Sukur Lashkar, my lord.
Son of late Mossad.
Abdul Sukur Lashkar is not here.
Abdul Sukur is 231, your lordship will find. 231.
So there your names are there.
There
And
my
what
names-
is your name?
No, our name has not been Milord in the.
So here your name is not there.
Not, but
So
the land-
therefore, the land have been acquired from them.
My lord.
No, yes, Milord, yes, Milord.
This is not a Bharatmala and all these things, whatever they may think, all these things. This is a normal acquisition.
My lord,
So if there is a dispute to that effect
my lord.
as to who is entitled to the compensation, the thing has to be decided by there.
My lord.
But the fact remains that you do one thing, you take the 50%,
My lord.
but with an indemnity that in the circumstance, the
Title suit goes in.
proceeding, not title suit has gone for a 6. It is
My
not. If in the proceedings there is any problem
My
that it is being held that they are entitled to, you are to refund the entire amount.
My lord, it's an indemnity bond, that I will do.
My lord.
And the balance 50% under.
Will remain, Milord.
Of 3H4.
Then it will be a case of apportionment.
Because the.
Which Mr. Roy Chaudhary objects, this cannot be a case of title. Title has to be done by the civil court.
No, well, I'm not saying that, my lord.
What are you saying?
My lord,
He
yes,
says that I should hold, in fact, day before yesterday, there was an order passed by the learned district judge, Dibrugarh. It came up before me. I asked the council to amend the petition. The reference was made to the district judge under 3H4 on account of the dispute. The district judge answers the reference and says that disputes can be looked into under 3H3. Okay. And these disputes can be looked into, they can very well look. Mr. P.K. Roy Chaudhary must have been influenced by that self-judgment, although you were not a party there.
No taxation.
So my lord, I think my the writ petition can be disposed of by this. Writ petition can be disposed of, my lord.
That is why I have put you on this side.
By interchange the matter.
Heard Mr. A.R. Bhuya, the learned counsel appearing on behalf of the petitioner. Mr. R. Babujari appears on behalf of the respondent number 1. You are appearing for 3. 3, na? 2 also. You can. So and so appears for respondent number 2 and 3. Mr. H. Sharma, the learned additional senior government advocate, appears for respondent number 4 and 5. And Mr. P.K. Roy Chaudhary, the learned senior counsel, assisted by so and so, appears for respondent number 6 and 7. A.R. Bhuya, senior counsel, assisted by so and so. The present writ petition has been filed by the petitioner, assailing the speaking order dated 7/1/2025 passed by the Additional District Commissioner, Kochar, and further seeking a direction upon the respondent number 4 and 5 to dispose of the representation dated 10/1/2025 and 24/1/2025. The brief facts which led to the filing of the instant writ petition is that for the purpose of building, bracket widening, oblique four-laning, etc., bracket close, maintenance, management and operation of NH 306 in the stretch of land from kilometer 0.000 to kilometer 20+000 in the district of Kachar. Acquisition proceedings to have been initiated under the National Highways Act 1956. The present writ petition amongst the various plots of land which have been acquired by issuance of notification under section 3D of the National Highways Act, tag number 15 of second RS Patta number 7, na?
15 and 16.
Tag number 15 of the second RS Patta number 7 have been acquired
It was said. So 15.
to the extent of the area mentioned in the 3D notification. During the course of the hearing, the 3D notification has been dated 21, which was issued on 21/7/2023, have been placed before this court, which is kept on record and marked with the letter X. From a perusal of the said 3D application notification, the names of the respondent number 6 and 7 and their predecessor is mentioned. However, No name of, however, names of the petitioners are not mentioned. It is further apparent from the materials on record that in terms with section 3H1 of the National Act of 1956, in terms with the award statement made under section 3G of the Act of 1956, the central government had already deposited the compensation for onward disbursal to the persons affected, persons interested. The petitioners who claim rights over the said land the respondent number 5, who is the competent authority of land acquisition, thereby raising disputes as regards the entitlement of the compensation and thereby raising disputes to the entitlement of the respondent number 6 and 7 to the compensation, and claiming apportionment of the compensation. The respondent number 5 passed the impugn order dated 7/1/2025. 7/1? Wherein it was mentioned that taking into account that the respondent number 6 and 7's name features in the 3G award and they were dispossessed from the land, 50% of the Jirat compensation may be paid to the respondent number 6 and 7 so as to enable them to shift from the site, and the remaining 50% of the amount would be of the Jirat compensation would be deposited before the learned district and session judge, Silchar, being aggrieved the present with petition. The learned coordinate bench by the present learned coordinate bench by an order dated
26/9/25.
26/9/2025 issued notice and directed that no amount should be released without taking the leave of the court. Respondent number 6 and 7 thereupon has appeared before this court and filed an interlocutory application for vacating of the order dated seeking modification, alteration of the order dated 26/9/2025, which is registered and numbered as IAC 867/2026. The said interlocutory application has come up for disposal before this court today. And taking into account that any order passed in the instance proceeding, that for disposal of the said proceeding, this court have to go into the merits. This court, with the consent of the parties, have taken up their instant writ petition for final disposal. The question arises in the instant proceedings as to what is the course of action which the respondent number 5 is required to take when there is a dispute as regards the entitlement and or the apportionment of the compensation, it is well settled that when there is a dispute as regards the entitlement and or apportionment of the compensation, the competent authority for land acquisition loses the jurisdiction to make payment. And that, to further to adjudicate such disputes. And the competent and the authority who can adjudicate such dispute has been mentioned in section 3H4 of the Act of 1956 to be the principal judge of the civil court, within whose jurisdiction the land have been acquired. In the instant case, as the acquisition has been carried out within the jurisdiction of the district judge, learned district judge, Kachar at Silchar, the proceedings under section 3H4 have to be decided by the learned district judge, Silchar. In the backdrop of the above, if this court takes note of the order dated 7/1/2025, passed by the respondent number 5, it would be seen, it would show that taking into account that the names of the respondent number 6 and 7 have been duly mentioned in the 3G awards, and this court also have duly taken note of that the names of the respondent number 6 and 7 have also been mentioned in the 3D notification, which is kept on record and marked with the letter X. The respondent number 5 had directed that the respondent number 5 have observed that 50% of the JIRAT compensation be paid to the respondent number 6 and 7 so as to enable them to shift from the site. The respondent number 5 has also observed by the impugn order that the remaining amount of the 50% of the JIRAT compensation will be deposited before the court of the learned district and session judge Silchar as per rule. It is the opinion of this court that the impugn order dated 7/1/2025 is to be in accordance with the provisions of section 3H4, 3H of the appears to be in accordance with the scheme of the Act of 1956. However, it is also the opinion of this court that if the petitioner, if the respondent number 6 and 7 are released the 50% of the compensation, there is a requirement of obtaining necessary surety so that in the event the proceedings under section 3H4 is decided against the respondent number 6 and 7, the said amount can be recovered from the respondent number 6 and 7 and paid to the petitioners. Accordingly, this court therefore disposes of the instant petition with the following observations and directions. This court directs the Respondent number 5, who is the competent authority of land acquisition, to forthwith upon receipt of a certified copy of this order, refer the dispute between the petitioner as well as the respondent number 6 and 7 to the court of the learned district judge Silchar. The learned district judge Silchar shall decide the said proceedings in terms with the mandate as contained in section 3H4 of the Act of 1956. Number 2. The competent authority, the respondent number 5, is directed to release the compensation of 50% of the GRAT compensation in favor of the respondent number 6 and 7. Upon undertaking being given by the respondent number 6 and 7 that in the circumstance the reference proceedings before the learned district judge Silchar is decided against the respondent number 6 and 7, they would hand over, they would return the amounts to the respondent number 5. Number 3. Remaining compensation of 50%, remaining 50% of the GRAT compensation. As regards the remaining compensation, 50% of the GRAT compensation, the same shall be deposited by the respondent number 5 before the court of the district judge Silchar, which shall be disbursed upon such decision as taken by the learned district judge Silchar in terms with section 3H4 of the Act of 1956.
Only by way of an indemnity bond, if your lordship may, that refund undertaking may be by way of an indemnity bond that your lordship will observe. That
These people are clever. I need not indicate.
they may ask me something else also. That is why.
That is the reason why I am not put it. Indemnity board, he has to file a suit. You can convince him with an indemnity bond, it is good. Why should I say?
Bank guarantee will be a difficult proposition.
Obviously, not bank. They would never say to be a bank guarantee. No, nobody. Surety means they always have the sureties. They do whatever. They know what is to be done. Don't make Mr. A.R. Bhuya clever.
No, Milord, I am.
And he would immediately put that thing there. Any other order here?
No, Milord, can be disposed of.
Dispose.
No, any further. It has already been disposed of.
No.
Any further thing?
No, not required. My lord. Obliged,
The
Milord,
writ petition accordingly stands disposed of, no costs. I, in view of the order passed so and so, interim order stands vacated.
My lord. Deeply obliged. In item 20, they are praying for some more time, lordship. They have already, we have received a letter from the department, lordship. They are praying 20 days more time as because they have already written to the assistant settlement officer regarding certain queries, lordship.
You have to file an affidavit.
Lordship, regarding order dated 18/3/2026, Lordship, and para 7, Lordship, details is given.
No, C 23/6,
Yes,
2026, I made it very clear.
Yes, Lord.
Fixes the matter on 10/8 on which state so-and-so are directed to place a report by way of an affidavit.
So that we have not received instructions, the department we have received later, they are praying for some.
Places in Sipsagar,
No, it's Kacha district.
Acha, floods.
No, the Kasar ADC lordship, I have collected his, I will be able to get the instructions. As because that item 5960, I have already
An
received the instructions.
opportunity is granted to the respondent number 2 and 3 to bring on record the affidavit as directed to be filed in terms with the order dated 23/6/2026. List this matter on 18th of September 2026.
I live place.
Item 26 lordship also directed us to get the instruction, my colleague lordship, HK Hazarika, he was appearing on that day, but he was, because of his illness lordship, he is hospitalized. Most probably because of that, he is unable to send any communication. There is no communication from our side. Lordship, may I pray some more? Yes, sorry. 24/6/2026. We are unable to get more, he is hospitalized lordship, because of that most probably he is not sending any letter.
Where?
I will.
Which place?
2 weeks. 2 weeks lordship.
Hey, Agonista, final opportunity is
Lordship.
granted to bring on record affidavit in terms with the order dated 24/6. Is the matter on 25th of September. Final opportunity.
Lordship.
Lordship, in this case, the issue is very
My
small.
lord, here the issue is, my lord, the petitioners, they are the investors under the Shahara group of companies, Shahara India company, my lord. In 2023, my lord, a writ petition was filed before the Honorable Supreme Court seeking disbursement of the investors' money, and accordingly the Honorable Supreme Court passed a direction in IA number 56308, my lord, should find that order of the Honorable Supreme Court, my lord, page number 302, my lord.
You have not got the money.
Yes. Now, the Honorable Supreme Court passed a direction to the Central Register of Cooperative Societies, directed the SEBI to transfer the fund to the Central Register of Cooperative Societies, and in turn, this Central Register of Cooperative Societies was directed to disburse the money. So, in terms of the direction, the petitioners submitted their documents and representation to the authorities to get their money. That was not considered. Accordingly, 2 writ petitions were filed before the Honorable Court, my lord, and both the writ petitions were taken together. But one of the writ petition was earlier disposed of, since the amount in that writ petition was small. Only 1,30,000 rupees was claimed in the writ petition, so it was disposed of. Here in this writ petition, my lord, the total claim amount is almost 78 lakh rupees. 78,57,260 rupees. Of the
You want a similar order like 15/9/2025?
25, my lord.
That's similar order.
That- Now,
Who are you? Lordship, I am for the cooperative societies, your lordship. The money is with us, your lordship. And that is not disputed, lordship. Thing is that, lordship, the money which we are allotted to us, we are dispersing in a level wise. First, initially, we are dispersing the money, we are releasing the money to the poor investors, lordship, whose cap was 1 lakh. Then we increase the cap, and now presently the cap is 10 lakhs. The investors who has for 10 lakhs, we are disbursing them after verification, lordship. Now the petitioner's case is that these investors are above 10 lakhs, lordship. So there are pan-India effect it is, lordship. In other high courts also there are, lordship, cases pending which are in disposal, lordship. May I place some orders, your lordship, if lordship likes to see?
But
of other high courts, Lordship.
What do they say?
Lordship, in one of the case of Chhattisgarh, Lordship, I'll just read the last para. Last two para. From the perusal of the above directions issued, it is appearing that the order passed by the Honorable Supreme Court will give, that is Pinaki Mohanty case, Lordship, will give benefit to all the depositors of the Sahara Group of Cooperative Society. The Honorable Supreme Court has also nominated a former judge of Supreme Court for supervising and monitoring disbursement of amount to genuine depositors of Sahara. Writ petition before Honorable Supreme Court is still pending consideration. As Supreme Court is already dealing with the issue involved in this writ petition, no defined order can be passed by this court in this writ petition. Consequently, taking note of the order direction passed by the Honorable Supreme Court, which is for the benefit of all the depositors of Sahara, I am of the considered view that no fruitful purpose will be served in keeping this writ petition pending. And if further and as such the writ petition disposed of, reserving
In
liberty.
other words, whichever High Court is saying that in view of the fact that the Supreme Court is in session of the matter, so therefore, Supreme Court is looking into it, and more particularly in the order which I have been
Actually,
saying,
Supreme Court, Lordship,
12/9/2025.
if I add, Lordship, Supreme Court has formed a committee where a former judge is appointed, Lordship. And that committee is handling the issue, Lordship.
So therefore, when the committee is handling the issue,
Yes.
and the matter is not having nature of the year and so, we further extend the till so and so for dispersal of the
31/10/2026.
remaining released earlier as well as the ordered so and so. So I think the matter is pending.
Pending in Supreme Court, yes.
So if the matter is pending, they will get the dues as per what are the, no,
Exactly.
because of the fact that the Supreme Court is looking into it.
Exactly.
The
Time will come.
petitioner cannot get anything if the committee says otherwise, because this court cannot direct anything taking into account that the Supreme Court is in session of the matter.
That was the view of the other courts, Your Lordship. In Allahabad orders also I have, Patna High Court's orders also I have.
That's the only order you can get.
I forward.
We'll get it. There's no
You will
quarrel.
get it.
They are looking into it. The Supreme Court is already looking into it. In view where we heard so and so, Mr. So and so. Consequently, and for the reasons mentioned in the application and the circumstances explained by them, we allow this application and direct that a sum of rupees 5,000 crores be transferred from so and so to the central register of IA. The needful shall be done within 1 week. Upon receipt of the said amount, the central register of cooperative society shall disburse the amount to the genuine investors under the supervision of Imane so and so. Having regard to the nature of the exercise being undertaken by the disbursing authority, so and so, learned Emir, we further extend time till so and so for disbursal of the remaining amount released earlier, as well as the amount ordered to be released today. So now, as of now, you are now to deploy. How much is the due of the petitioner?
78 lakh rupees.
Lordship, total
78 lakh.
78.
Total 78 lakh.
There are
Huh?
4 petitioners. Total. Lordship may peruse the petition, Your Lordship.
Total 4 petitioners and their, my lord, the family member,
Had the
husband, wife.
petitioner's case come within the ambit of this 5,000 crores or not?
Lordship, that will come, that will see after the cap is increased, Lordship. After verification, we'll see, Lordship, that we cannot assure it now, Lordship.
And my lord, the other thing is,
Because now the cap is 10 lakhs, Your Lordship.
although, my lord,
The matter is taken up by the Supreme Court. The Supreme Court will look into that. There's no worry on that.
in fact, my lord, the earlier this order passed by this court, my lord, in 2025, this order passed, my lord, earlier.
See, the problem with that order is we cannot direct. The moment we direct something,
So, my lord,
there's a procedure or a manner in which the Supreme Court is looking into it for the purpose of disbursal. Now, on the basis of that, the committee is now deciding that they will first decide, allow 1 lakh, then 2 lakh. Now they have gone to 10 lakhs. So then you may go to your amount will be some 13, 14, 15 lakhs.
Lordship, the lowest is 14 lakhs, Your Lordship.
14 lakh, very nearby. One of you will be getting it soon. The remaining will be getting later on. 14 into 4 is how much?
No, Lordship. Petition number 1
petition number
is
1, my lord,
26 lakhs 75,000. Petition number 2 is 17 lakhs 35,000. Petition number 3 is 13 lakhs 36,000. And petition number 4, 16,64,000.
Is it on the basis of one instrument or various instruments?
Various, Lordship.
Huh?
There are various shares, Your Lordship. There are various bonds, different bonds, Your Lordship.
Are you
One
doing
is
it as per one bond, one petitioner, or as per how much holding up? One petitioner holds, or how much is one?
one
bond?
petitioner, one petitioner.
So if the petitioner had in the meantime put this 1 lakh or this 14 or 30 lakhs into 5 accounts, then he would have got it.
My lord, the
No, Lordship, by name wise, Lordship, we are,
So you're doing it as per name.
yes,
So
yes,
how
Lordship.
many
The total
shares?
installment, yes,
the
Lordship.
petition number 1 purchase total, my lord, total number of bonds, my lord, that page number 6 of my petition. Total number of bonds are
99 bonds, Lord.
total 99. Total 99 bonds were purchased by the petition number 1, and the total maturity value of that of those bonds was is, my lord, 26 lakh
No.
75,000.
Not Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr.
And-
DJ Das, the learned counsel who appeared.
Well, the other problem
1
is,
and 2, Your Lordship, 1 and 2.
my lord, only one information I like to bring to the honorable court, my lord. In fact, the earlier writ petition was disposed of in 2025. In that writ petition, the only small amount was there, 1,30,000. Still, that amount within the last 1 year, they have not paid. They have not disbursed that only 1,30,000 rupees.
That is a separate case.
And the only problem is, my lord, since the earlier.
You are for,
Number 3.
and so senior counsel assisted by so-and-so appears on behalf of the respondent number 3. The petitioners herein are investors. Under the investors of the, what is that?
Sahara Group of Cooperative Societies.
Sahara
Group of Cooperative Societies. Well,
Group
there are
of Cooperative Societies. Cooperative Society.
Cooperative Society Limited, Lordship.
well, Sahara,
Cooperative Society
well,
Limited.
well, there are actually 3-4 different names of the company and for different projects. Sahara Real Estate Corporation Limited and Sahara Credit Cooperative Society Limited. my lord. In synopsis of my report,
Okay, are investors in the various entities under the Sahara India Parivar.
Yes.
Whose claims come within the ambit of inverted comma Sahara SEBI Refund Fund. There are as many as 5.43 crore persons who have invested around 1,13,504.24 crores. What's- As on 12/9/2025, refunds have been issued to 26,25,090 genuine depositors, totaling to rupees 5,053.01 crores. Out of their claim of rupees 6,163.55 crores. In addition to that, various other persons have also filed, various other investors have further filed additional claims, which comes to around 7,849.95 crores. As regards this refund to the investors, the Supreme Court is still in session of the matter. In the case of Pinak Pani Mohanty versus Union of India, and in the last order, which was passed on 19/12/9/2000, last order,
Lordship,
Yes.
in this case, Lordship, yes, Lordship.
12/9/2025.
No, that is a separate case, Your Lordship.
No, in this case,
Yes, Pinak Mountain, 12/9/2025, that is the last order.
in the last order passed by the Supreme Court on 12/9/2025, the Supreme Court directed rupees 5,000 crores to be transferred from the Sahara SEBI refund account to the Central Register of Cooperative Society. And there was a further direction that the Central Register of Cooperative Societies shall disburse the amount to genuine investors under the supervision of Mr. Justice R. Subhas Reddy, a former judge of the Supreme Court, in the manner as already directed by the Supreme Court in the order dated 29/3/2023. Mr. D.J. Das, the learned counsel appearing on behalf of the respondent number 2, submitted that taking into account that the amounts have been paid have been transferred to the Central Register of Cooperative Societies in installments from the Sahara SEBI refund fund, first priority has been given to those investors, to those genuine investors who have the minimum investment. Initially, those who had the minimum investment of rupees 1 lakh have been disbursed. At present, investors who are having claims of around 10 lakhs are being disbursed their dues. In the instant case, the learned counsel further submitted that in the instant case, the petitioners investment is much higher. And once amounts are being transferred, and the petitioner and transferred and are transferred to the Central Register of Cooperative Societies, around 10 lakhs. The learned counsel for the respondent number 2 further submitted that the amounts of claim of the petitioners are much higher, and their entitlement for the disbursement would arise as and when the decision is taken by the committee so appointed by the Supreme Court. This court has given an anxious consideration to the subject matter of the present proceedings. And it is the opinion of this court that as the Supreme Court is in session of the matter and also taking effective step, passing directions as to how much amount is to be deposited to the account of the respondent number 2. And a committee have been appointed for the purpose to oversee and supervise such disbursal. It would not be proper on the part of this court to pass any directions in the present proceedings. Accordingly, this court therefore disposes of the instant petition with the observation that the respondent number 2 shall make payment to the petitioner upon due verification as and when funds are provided on the orders passed by the Supreme Court.
After they found to be genuine. Upon verification process.
No, very, didn't I say that?
Yes, Lord.
Very well.
May I plead your lordship? Lordship, before my senior starts your lordship, I want to pray something your lordship. The dealing council MSP Chakraborty is not available today because of medical ground your lordship. So
On account of?
medical ground your lordship.
Okay, Miss Ardeka, the legal counsel appearing on behalf of the Water Resource Department submits that Miss P. Chakraborty, who is the standing counsel of the Water Resource Department, is not available. And therefore, this court may accommodate the Water Resource Department, taking into account this matter on 14th of September 2026.
My lord, one my lord, prayer, my lord. There is an order on 1/6/2026 to file an affidavit from their side, my lord. They took time several times. my
In the
lord.
meantime, the Water Resource Department shall bring on record the stand by filing the affidavit.
Oblige.
Yes, what is this?
DMC council is up there. Your lordship had heard your lordship matter. They have created a dispute, your lordship, regarding the payment of contract person. Your lordship may kindly come to their affidavit, your lordship.
Mr. Nayak? Normally, when the junior advocate appears, I allow, if I have to allow, I allow it.
Lords,
Whenever I pass an order that Mr. So-and-so appearing on behalf submits that his senior is not available, meaning thereby something is wrong. What was this? I wanted to dismiss.
lordship. Lords.
Lordship said, let your senior come on that day you will dismiss.
Eh?
On last day,
Yes.
lordship,
He was doing your lordship, therefore I came, your lordship.
No, he's doing it. So then I said, no, I won't
Lordship,
dismiss
Lord.
senior.
I will, your lordship, only two
What was the case about? This was pertaining to certain certificates, na?
certificates, your lordship, what they say, your lordship, that the work, your lordship, for 2 years I have received the amount. For third year, your lordship, 33% was released to me and 66% was not released, your lordship. Then I came before this honorable court and then they came and filed an affidavit, your lordship. Will kindly come to the affidavit para 4, your lordship, page 35. This is how they have created a dispute, your lordship. That as regards the affirmance made in paragraph 10 of the instant writ petition, the deponent begs to state that particulars of the work was inspected by deed and executive engineer. Your lordship will kindly note that Division 5 GMC and completion certificate was issued by deed and executive engineer of the respective division. Accordingly, The file was processed for further necessary action to the higher authority of GMC. However, it was observed by the superior authority that no documentary evidence of supervision carried out from third-party monitoring agency was furnished, which I have annexed in my writ petition, Your Lordship. Further, no documentary photographic evidences regarding status review monitoring of the entire allotted work was furnished by the then concerned Executive Engineer Division 5 GMC, except the completion certificate, Your Lordship. So far as Your Lordship, their case is that photographic instances are not there. Then third paragraph. In consideration of the same, the superior authority GMC has constituted a committee to take decision on matters pertaining to release of huge amount where the issue of public money is involved. After verification of all records, the committee has rejected the work carried out as claimed by the contractor on the ground that the work is not verifiable on the ground and the photographs do not suggest completion of the work. On the one hand, Your Lordship, there is no photographic evidence, and secondly, they say photograph does not, Your Lordship, do not suggest completion of the work, number one. Number two, Your Lordship, at the very first line of that paragraph says, Your Lordship, the work was inspected by the executive engineer and did an executive engineer and completion certificate was issued. And based on that, Your Lordship, 32 years paid, 33% of the last year also paid to me, Your Lordship. Now, if at all I have not done the work, and Your Lordship will kindly note, this verification has been done. I have completed the work in 2020. The 20 and the verification has been done in 2024, Your Lordship. How the evidence can be got, Your Lordship, whether I have done the work or not, Your Lordship? It's a cleaning and maintenance of the work, Your Lordship. And finally, Your Lordship, even if at all there is something hanky-panky is there, how you have proceeded against those officers, Your Lordship? They have not proceeded against this. If I have got illegally got the money, then they will have to at least proceed against them, Your Lordship. Now they have created this dispute for the sake of creating a dispute, Your Lordship. After acting on the same materials, suddenly they say that we cannot act on these materials. Is it not in Your Lordship dispute for the sake of dispute, Your Lordship? Had it been a case, Your Lordship, that the very first year, they have said that you have not done the work properly, there is no evidence, etc., then yes, I don't have any case, Your Lordship, in that case. But after paying me for 3 years, 2 years, and then 33% for the third work, now when it turns come to pay this 66%, then you say that no, you have not done the work.
No, while paying you the 33%,
Lordship.
they were satisfied.
They were satisfied, Your Lordship, based on the same documents, Your Lordship. Now, when the rest, question of paying the rest came, Your Lordship, rest of the amount came, then they say, no, you have not done the work. And now, if you have not the documents, evidences of completion of the, it is not my fault. It is your duty to keep it in the record. Photograph, third-party inspection, everything. And if Your Lordship sees the third-party inspection, categorically mentioned that superintending engineer has also visited the place along with this third-party monitoring authority, that is the authorities of the Guards Polytechnic.
You have filed a reply.
Lordship, we have filed the reply.
What do you say?
Lordship.
What do you say in your reply?
Lordship, my reply is page 39. Para 6, the deponent denies the averments made in sub-para 1 of para 4 of the affidavit in opposition. It is stated by the deponent that completion of the works by the deponent, the work was monitored by PCPS Girls Polytechnic Gauhati 21. After proper verification by the third party, finding the work satisfactory, third party monitoring certificate was issued by letter number so-and-so dated 16/12/2020 for package number so-and-so dated 16/12/2020 for package number, these two packages. As regards the averments made in sub-para 2 of para 4 of the affidavit, deponent begs to state that Executive Engineer Division 5 GMC issued completion certificate after proper verification of all the relevant documents. Had the documentary photographic evidence regarding status, review, monitoring of the entire allotted works not furnished by Dean and Executive Engineer, the authority ought to have taken action against the said officer. Till that, they have not taken any action against any officer.
When was the, as per your tender document or your work order, when was the inspection required to be carried out?
Lordship, after, during the work, your Lordship.
And during the work it was done.
Lordship, that is what your Lordship, my instruction is, and your Lordship, the certificate also says so, your Lordship. The Your Lordship may kindly come to page 28, your Lordship.
Are these persons the third party monitoring? Annexure 1 and 2?
Lordship, page
44.
28, your Lordship may kindly.
Page 44.
Last, Lordship,
Page 44.
the same, your Lordship, 28 and 44, your Lordship.
Are they the third party monitoring?
Yes, your Lordship, this
Who appointed them?
GMC, your Lordship, not by me. It is the GMC who appointed them, your Lordship.
And this is after the completion of the work.
During the work, your Lordship. And after this, your Lordship, executive engineer visits and issues a completion certificate, your Lordship. Now, your Lordship will find page 28, your Lordship. It says, this is to certify that the above mentioned work was monitored by us during the execution by the above named contractor as third party monitoring agency. We also inspected the work done subsequently after execution and found it in order. There's a one, then 3 persons, your Lordship, signed it.
And then they carry out the inspection in 2024.
Then, your Lordship, the new, the committee was constituted. So they probably then they went there and found that nothing.
The committee was constituted for which work?
This work, your Lordship, they say, they are
only for this 66%.
Lordship, probably, your Lordship, because that has not been disclosed by them in the affidavit. It says it was sent to the superior authority. They found that no photograph is there. And to my instruction, your Lordship, it is in 2024 this committee was constituted. Not only in respect of this, there are other cases also which has been rejected by the committee. In some cases, this honorable court were, Lordship, not the similar nature of work, different work, your Lordship, the payment was directed to be paid. But so far as this is concerned, your Lordship, they have not disclosed in the affidavit the date, etc., when the committee constituted, what are the materials they have taken into account, that is not there. Para 4, your Lordship may kindly see.
Let's see the records.
Lordship, Lordship.
Then we'll get to know.
Lordship.
With the order, with the superior.
Lordship. Record will reveal everything, your Lordship.
But Lordship, may at this stage only, go through the completion certificate once, Lordship. The first one is at Lordship. Lordship will find this at page 24. Page 24. It is something dated March 2019, Lordship. In the next page, date is somewhat visible, Lordship. In the
First year and first year maintaining.
Lordship, only note that portion. First year, first phase, first year
We are
maintenance.
concerned with the third year.
Huh?
They are concerned with third year. First year, second year, they have paid, your Lordship.
Second completion certificate is at page 27.
Second year maintenance bill.
Again, first year, first phase.
Completed the first year maintenance. Second year completed by the contractor satisfactory, and third year maintenance going on.
Then the next one, Lordship. Page 29. Again, first year, first phase.
What is the date of this document?
It is, I think, May
2020.
25, 2020.
And,
Another
and
complete.
why, and this is the next one is for 2/5/2020,
Yes, then next one is at 31.
third party monitoring. This is third party monitoring. you know.
No,
This
this
is
is
third party.
completion certificate.
29 is different work.
Two works, your
Same
lord,
work, lordship. This is, I mean,
two works. One is Z and one is F.
I'm at page 2662, 2024, lordship.
Page,
This is BZ, page 29, lordship has seen.
Ah.
Next completion certificate is at page 33.
Ah.
Lordship will again find first year, first page.
and third year maintenance.
Yes. So all these certificates, lordship, pertains to first phase only. And so far as the third party monitoring certificates, lordship, it starts from page 20. Work period was between 18 to 2020.
18 to 22.
20. And a 20, page 20, lordship, this is the third party monitoring. This is for the period March 2018 to May 2018. Lordship will come to the next third party monitoring, lordship.
Into May, March to May.
Lordship. Lordship will see where one period is missing.
Then first of year 2018.
From May to December 2018 missing. Lordship will see the period 1/12/2018 to 31/11/2019.
This is they have paid.
Same thing, lordship will see page 28. Here also, lordship, this certificate is silent about the period May to December 2018.
1/12/2018 to 30/11/2019. Now, your lordship.
So lordship, let me place the record. Lordship
Record,
will
your
see the record, lordship. Lordship will see the record and lordship.
Now, what is this period? The contract ended when?
2020.
2020, your lord.
When?
I think it is March, lordship.
No, no, 31
Or-
10/2020, your lords. That is the till October, your lords.
Work order likha ase eto.
First, your lordship work is cleaning, your lordship. For first period, your lordship. Then make
And now this requirement of a certificate by the third party monitoring
lords.
is required under what provision?
Your lordship, in the tender, there is a provision, your lordship, but my friend has also not been
No,
able.
no, I have seen, lordship. I mean, from other tender agreements, I have found that clause, lordship. One, I think it is page 60 or something in the tender document, lordship, in the agreement, lordship.
No, my
There is a
question is, no, there's a reason why I'm asking. You see, the period is from 1/12/2019 to 31/10/2019. Earlier, they used to give for 2 months, 3 months, 4 months, or whatever. it may be. Now here, for the last 2 years, they have given it for almost 1 year. Get the point? Here, kindly see. See first, page 20, March 2018 to May 2000. Okay. Then you see the next one, March 2018 to May, this is also. Then you see
Lordship,
1/12. In the meantime, there is a gap.
Work order was issued on, I mean, 27/3/2018.
Okay, so March.
So March was almost over, lordship, at that.
Whatever may be, they have given. Now kindly see, there is a gap.
Yes.
From June to November, there's a gap.
Yes, lordship.
Then they have from 1/12/2018 to 31/11, now almost 1 year.
Yes.
And therefore they use the word, here they don't use the word here. But if you see the corresponding out here, page 32, and so, they are now stating that this is page 30 and 32. This is also for almost 1 year. 11 months.
Lordship.
Now, in these 11 months, they are saying the word generally. Generally, we are accompanied by junior engineer. My question is, if they are making the third party inspection, why is the third party inspection required? Because it may not be feasible on the part of the others to keep on inspecting everything. So therefore, you have employed somebody or asked somebody or appointed to carry out the third review. Now, what is the frequency in which the inspection is to be carried out? This is a very important consideration as to whether the inspection has been carried out just for the sake of it, because these are all these certificates are given in the month of December 2020.
Last certificate.
Huh?
Last
1612. They are given in the month of December 2020. So therefore, why this inspection? So when there is a third party inspection required, and obviously required, therefore this particular certificates the petitioners have also procured these certificates, because these certificates were issued. How did the petitioner get hold of these certificates? Because these are not copied made to you, so
Lordship,
they were given to you.
Not made to you. After Your Lordship, probably Your Lordship, he has somehow got the copy. That question has not been put to me, that I will.
In the affidavit, Lordship. Here it is stated, observe that superior authority that no documentary evidence of supervision carried out from the third party monitoring agency were furnished.
Now, how did this certificate come into your hand?
I have obtained it, Your Lordship, probably from, I will have, because I have not taken that instruction as of now, Your Lordship, but probably, Your Lordship, when that he has told me that it was been taken from the office, Your Lordship. That's what he has submitted to me.
So they
And this-
submitted directly to the office.
No, they directly, and Your Lordship, that is what I wanted to submit, Your Lordship, that I have been told, Your Lordship, that while doing this monitoring, they have their own books, Your Lordship, where they record that, Your Lordship.
So the measurement book, the inspection book must have been there.
With the authorities, Your Lordship. That I cannot get, Your Lordship.
So if that is so, there is a requirement, if there is a case of requirement of a measurement book, then that will be there. You may not only regard with the certificate, but whether there is a measurement book. Whenever the inspection is there, whether they maintain a detail, because here we are concerned with almost 11 months and the certificate is given after 1 year.
They're not construction works, Lordship. These are cleaning of
Cleaning
drain,
work.
Lordship. So
Whenever there is an inspection being carried out, they are saying that we are generally accompanied by so and so. No, they say the work is satisfactory. Now, if on the basis of their certificate you are going to pay, therefore, under no circumstances, because therefore, in a cleaning work also, when there is an inspection being carried out, are documents not maintained?
it should be, Lordship.
As to,
It maintains, Your
because
Lordship.
if there is no maintenance, anybody can give anytime a certificate.
Lordship, but one thing I would like to just inform you, Lordship. Lordship, this is one issue, Lordship, which is very sensitive issue, Lordship. And in respect of this issue, only one vigilance inquiry is also going on. And so many persons were arrested.
This is not in respect of our work. Your
I don't know whether this
Sir,
particular
not-
work
not-
also.
Mr. Nayak, sensitive, not sensitive,
they are
hardly matters.
They are just careful.
I'm not on that. I'm
No.
not on that. My question is, if they are entitled, they should. Otherwise, if they are not entitled, they should not. I'm very particular on that. Now, if there's a requirement of maintenance, and if it's not there, then obviously your department should take necessary steps that whenever an inspection is there, there has to be a minuted. Now, here is a certificate, therefore, it's been given after 1 year. Then we found everything is good. That is why I put the question, how did the petitioner get all of these documents?
Lordship, yes.
Because if the petitioner, it was, because no, you see the third party also, whoever it is, unless they are so much public spirited to give the certificate on their own, something must be there.
I understand.
So therefore, the thing is then requires a mechanism for having the, like in PWD and all, you have a measurement. Every time there is a measurement, because it is maintenance or desilterization is a continuous process which they have to keep on doing it. And if they are doing it, whether they have checked on the particular day, when they were there, these logbooks should be there, something to that effect. Now, if those logbooks are there or not, if there is not there, then it's a very serious thing. Obviously, then the petitioner have to go to before the civil court. These are things which needs to be looked into.
Let me, try to find out, Lordship, what, inspection mechanism they followed, Lordship.
Because this court, Mr. Naik, I tell you, unless there is a clear-cut admission, this court finds it very difficult to pass that order that pay. Even after a clear-cut admission also, then also I ask them to verify. Because I don't believe the executive engineers, superintendent engineers, no.
That
It
is
has to
even
be
my
by the chief
difficulty.
engineer.
Yes, Lordship. That is why I am submitting nothing so far as these divisions are concerned.
So therefore, unless the chief engineer does not certify it, I do not say no. And then only it can happen. So therefore, I am very particular on that. But if it is a case that, yes, because one has to understand his entire case is banked upon these certificates. The third party has inspected, they found everything good. Along with that, there is a completion certificate. You say there is no photographs. Now, whether it is a requirement that photographs, whenever inspection is required, to be taken. These are things which needs to be looked into. And if those are things which are needs to be looked into, if we get a more clearer picture, then we can very well pass an order, direct them to proceed with the civil court. This is the only way out. But, because merely because of the fact that two-thirds of the amount of the third year have not been paid. He says that all other things have been paid. Yes, you may have been satisfied with that. Or it may be the thing that you have followed the same practice and later on became more vigilant after paying. Instead of going for recovery, okay, let us not pay the remaining. It may happen like that also. Huh?
That is also
The open eyes. And mainly because of the fact that you have committed a mistake earlier cannot be a justification for directing payment also. Isn't it?
Yes, Lord.
Anyways. This court have heard the learned counsels appearing on behalf of the petitioner as well as the respondent at length. For the purpose of deciding the dispute, and the basis on which the respondents have claimed that basically have arrived at the opinion that the claim of the petitioners made in the writ petition are to be rejected. And it is the opinion of this court that the basis on which the respondents have rejected the petitioner's claim made in the instant writ petition can be discernible from the records maintained by the state, by the respondents while arriving at their decision. The exercise of jurisdiction under Article 2 to 6 is only to see as to whether the decision-making process in rejecting the petitioner's claim suffers from unreasonableness, arbitrariness, or irrationality. Considering the above, this court therefore directs the respondents to produce the records from where this court can discern the basis on which the petitioner's claims have been rejected. List this matter on
3 weeks, Lord. After 3 weeks.
11th
Lord.
September.
Lord.
Deeply obliged.
Showing it as part of.
Obliged.
Why should this court decide?
My lord,
Go to the jurisdictional magistrate, they will look into it. You have converted this court to a jurisdictional magistrate. Mr. Sharma. No, go there. Law is very clear. In fact, with due respect to the coordinate bench, after recording the judgment of the Supreme Court in Sunderbhai Amla Malai Desai, the court should have said that go to the jurisdictional magistrate, not this court. Heard Mr. H. J. Sharma, the learned counsel appearing on behalf of the petitioner, Ms. Udas, the learned counsel appearing on behalf of the respondents. The present petition has been filed by the petitioner seeking compensation on account of the loss suffered by the petitioner due to the negligence of the respondent authorities. It's the case of the petitioner that the petitioner, which is a proprietorship firm, is the registered owner of a goods carrier truck bearing registration number AS25CC7741. The same vehicle was seized on 10/2/2022 by the police under the Sangsari police station in connection with Sangsari PS case number 77/2022. Under sections 120B, /379, /411, /465, /468, /471 of the IPC. However, at the custody of, when the vehicle was in the custody of the police authorities, the said vehicle was gutted in the fire which took place on 11/2/2022. The petitioner thereupon approached the concerned respondent authorities for the purpose of providing compensation to the petitioner, and the same having not been done so, the petitioner has approached this court by filing the present petition.
we have filed our affidavit, my lord.
This court duly takes note of. A BNS condition. Now, what is the corresponding provision? Yes. Yes, where is the corresponding provision, madam?
My lord, BNS section
Huh?
451, my lord,
451 has become now what?
97, my lord. 497.
497. Sure. Court finds it pertinent to take note of. When did the incident happen?
My lord, 10 to 2022, my lord, 10th of February, my lord.
22.
11 to seized, my lord, on 10 to 22 at 4:30 PM. And my lord, that burned on 11 to 22 at 3:20 AM, my lord, morning, my lord. 11 morning.
Finds it relevant to take note of. That's section 451 of the Code of Criminal Procedure 1973, which was holding the field at the time when the incident was happened. Empowers the court, the jurisdictional magistrate to pass appropriate orders with regard to properties which are seized by any police officer for proper custody pending conclusion of the inquiry or trial, semicolon, to order it to be sold or otherwise disposed of after recording such evidence as it thinks fit, as well as if the property is subject to speedy and natural decay, to dispose of the same. This court finds it relevant to take note of. The judgment of the Supreme Court in the case of Basaba Kom Dayaman Goda Patil versus the state of Mysore, reported in 1977 for SSC 358, wherein the Supreme Court dealt with the case where the seized articles were not available for being returned to the complainant. In the same case, the recovered ornaments were kept in a trunk in the police station, and later on it was found missing. And the question was with regard to the payment of those articles. In that regard, the Supreme Court observed that paragraph number 4 that the object of the code seems to be that any property which is in the control of the court, either directly or indirectly, should be disposed of by the court, and a just and a proper mode should be passed by the court regarding the disposal. Further, in the criminal case, the police always acts under the direct control of the court and has to take orders from it at every stage of an inquiry or trial. Supreme Court further observed that the court exercises an overall control on the actions of the police officers in every case where it takes cognizance. Paragraph 4 of the said judgment being relevant is reproduced here in under. The Supreme Court further in the said judgment, taking into account that there was no prima facie defense taken, the state or its officer had taken due care and caution to protect the property. Observe that the magistrate, the jurisdictional magistrate may in appropriate case where ends of justice so require order payment of the value of the property. It was also observed. It is also seen that in another judgment in the case of Sundar Bhai Ambalal Desai versus State of Gujarat reported in 2002 10 SCC 287. The Supreme Court, relying upon the judgment in the case of Basoba Kom Dayamondi Patel Supra, asked various directions. As to how the court, the jurisdictional magistrate should exercise the powers under Section 451 of the Code of Criminal Procedure. In the instant case, it is seen that the vehicle in question was seized by the Sangsari police. You have seized it, na?
Yes, ma'am.
Seized
With
the
garment to
Sangsari
garment.
by the Sangsari
Police station.
police outpost or police station. Where's the seizure?
Sanctuary PS Malad police station.
Huh?
Malad seizure.
Seized the truck bearing registration number AS 25CC 7741 by the Sangsari police station, by the officer in charge of the Sangsari police station. Is it? Who had seized it? Seized by an official of the, by a police or by an authorized officer of the Sangsari of the North Gauhati OP
Yes.
outpost, which falls under the Sangsari police station in connection with Sangsari PS case number 77/2022. The seizure was made on 10/2/2022, and thereupon seizure made when?
Lordship, same day, Lordship, it was taken into custody. Lordship, no extra seizure has been made.
Because Malad under
Because the next day it was burned, Lordship, no
morning
seizure.
part. Evening Malad 4:30 it was seized and Malad following the morning.
When? Date
Following the next day.
2/22 it was seized at 4:30 PM
was seized at on 10/2/2022
February. Yes, ma'am.
at 4:30 PM.
PM.
And thereupon, while in the custody of the North Guwahati police outpost, the said vehicle caught fire. Resulting in total damage to the vehicle.
Yes, Lordship.
It is the opinion, sir. The petitioner thereupon have sought for compensation from the respondent or concerned respondent authorities. And the same having not been granted, the petitioner has approached this court. It is the opinion of this court that taking into account that section 451 of the Code of Criminal Procedure 1973 and the parameteria provision of section 497 of the Bharatiya Nagarik Suraksha Sanhita 2023 are adequate statutory remedies available to the petitioner. And more particularly, in view of the judgments in the case of in the case of Basaba Om Dayanmo Goda Patel Supra and Sundarbhai Amlai Desai Supra. This court ought not to entertain the instant with petition. Rather, the petitioner should be relegated to approach the concerned jurisdictional magistrate. According the writ petitions, therefore, stands disposed of with the following observations and directions. Number one, taking into account that the petitioner has statutory remedies available under section 451 of the CRPC oblique 497 of the BNSS. This court is not inclined to entertain the writ petition under 226 of the Constitution. And more particularly, taking into account that disputed questions of facts which arise in the instant proceedings. Number two, the dismissal of the instant petition on the ground of being not entertained shall not prejudice or preclude the petitioner to approach the concerned jurisdictional magistrate under section 451 of the CRPC oblique 497 of the BNSS if so advised. It is further observed that in the circumstance the petitioner approaches the learned magistrate, jurisdictional magistrate shall duly consider the law as laid down by the Supreme Court in the case of Edutanam Didio Supra Supra. Yes, madam.
Matter relates to non-payment of bill, Lordship.
What?
Yes, Lordship.
I thought a contract, non-payment of bill has become so big.
Lordship, for original work I have already paid. For additional work that is pending rupees. That is pending, Lordship.
Additional work is, there is a contract.
Lordship that is permitted, Lordship that is directed by the respondent authority. And then I have there is a complication certificate also, Lordship, after that. And there is, that is amount is.
Not Lakhimpur.
Yes, not Lakhimpur College, Lordship. For construction of synthetic track, Lordship. For construction of synthetic track, Lordship.
The complication in the matter lies that originally the Ministry of Sports and Weight Healthcare, my lord, had granted a sum of 5 crores 50 lakhs to the North Lakhimpur College to construct this particular synthetic track. Now they in turn contacted me, my lord, that is the NPCC, that you employ contractors on an agency service basis and get the work done. Accordingly, we have appointed them, my lord. Now my funding is the owner of the project.
Who?
And my funding, NPCC who got the fund from the college, who in turn got it from the ministry. And
No, ministry paid to not
college.
Not Lakhimpur.
Yes.
Not Lakhimpur College.
Not Lakhimpur paid to MPCC.
Yes.
NPCC
MPCC employed them.
employed.
She's asking the money from you.
So from all the respondents together, my lord.
I am from.
No, let me just complete. What had happened is that this 5 crores 50 lakhs originally was spent in construction of this particular track.
Now, why the dispute?
The dispute, my lord, then came because during construction, my lord, it was felt and they wrote to us and we also, my lord, certified that because of weather conditions there, unless and until you put a UV coat on the entire track, acrylic UV coat, this is not going to sustain. The entire project would otherwise be a failure. So we, in turn, my lord, wrote to the college for approval. The college approved the said variations to be done. Accordingly, we directed completion. Now, after completion, when the bills were raised, my lord, since this had exceeded this 5.5 crores, the college did not have money to pay. They in turn wrote to the ministry. The ministry says that, no, we had given it as a one-time grant and we therefore cannot pay anything further, my lord. That is how the matter is stuck now. Otherwise, even though there is no contract, my lord, on contempt merit basis, they would be, otherwise, on contempt merit basis, my lord, they would be payable. It will be payable because the work is certified to be completed and
In fact, Lordship,
otherwise.
out of that extra additional cost, some payment has been made, Lordship. 48 lakhs 92,000, so 10 lakhs already paid, Lordship. Now
That was-
38 lakhs
that was from-
92,000.
That was from a balance project cost that was remaining from the original tender value. So that has been released.
Petition,
So far as we are concerned, my lord, we had sanctioned 5.5 crore. It was made very clear to the college that any amount you spend over and above that 5.5 crore, you have to spend from your own pocket. You have to pay. So that is on record. Lord, we kindly come to page 155 of the petition, my lord. The petitioner, they have annexed that letter, which we had sent to the NPCC. So, my lord, above 5.5 crore, my lord, we cannot pay.
Not looking good.
Not looking good. Well, central government has paid us, released us 5.5 crores. Already we have transferred it to the NPCC. That is S1 and R1. And now, actually, we have written, first proposal come from the NPCC that.
But how did the price go up?
My lord, this was an additional work to be done. The original contract value was within 5.5 crores. When you put up this UV code thing, my lord, on the entire
So
track.
why didn't you take
additional
the,
cost.
why didn't you ask the central government?
My lord, because I have no relationship with the central government.
Understood.
My
You
owner
asked-
is,
You asked, not looking for.
not,
Not
they approved it.
Not talking about approved it,
They approved
but they did not correspond with the central government.
They corresponded
corresponded.
on a later stage, my lord. They corresponded and ministry ultimately says that no, it is a one-time grant that we have given, so we cannot exceed that particular
So
grant.
you have to pay.
My lord, we can pay directly to the petitioner. Because petitioner is the respondent number one is our agent. We have to pay to the respondent number one. And for that, any dispute,
The respondent number one would not mind if you pay directly to the.
already we have paid total amount,
Huh?
my lord, total amount due to the petitioner is, I think, 5 crore 40 lakhs, 47,75 something. And already 5.5 crores is paid to the respondent number one, that is NPCC. They may.
So total is 541.
No,
and
that
for-
540 was the
for-
bill for the original work. Then this, they said that this 10 crore, this balance 10,
Not 10
550.
crore, 30.
Sorry, 10 lakhs.
In
That
fact,
balance we have also paid.
91 lakhs, Lordship, not 5.5 crore. For original work, I have received 4 crore for 91 lakhs, Lordship.
Actually, my lord, between us agreement.
So you have to get it from him.
Yes, from him, that is in, as per our agreement, Lordship. As per our work order also, I have received 4
Who is
crore,
he?
1 lakh.
Who is he? Who are you?
My lord, the college appointed
Whatever
me as
the
the
college
agency.
appointed. Who are you otherwise?
My lord, we are the agency through which the
What,
contractor. has
what type of agency are
My
you?
lord, on 7% commission basis, we had done the work because there is an agreement, my lord, with the college.
What type of agency you are? Government agency, private agency?
No,
what
no, I
is
am a government agency. my lord. I am a government agency. NPCC is a corporation, my lord.
So you do work on commission basis?
My lord. Ministries, my lord, appoint us to monitor projects and for this engineering and monitoring costs, my lord, we, my lord, take a agency charge.
So you pay it to them?
My lord, the question is that our contract clause with them is very clear that the money has to be paid from the owner and therefore owner's approval in all cases is required. So unless and until
But
the
did
owner
you
pays
issue-
us,
did you
we
issue
don't
a
have
wo-
funds.
No,
to
no, but
pay.
did you issue a work order to them? Additional,
My lord,
additional work order did you issue to them?
In fact, agreement also amended later on, Lordship. That agreement
Yeah.
between, that is amended
that was done because the college has approved it.
for additional work.
The petitioner has no privity of contract with not looking for or the state government, the central government, it is with you, you pay. Therefore, I ask
But then,
you, are you government?
the clause 37.1, my lord, has to be then rewritten, my lord. 37.3, my lord, is the contract between me and the petitioner, which clearly says that, my lord, how payments are to be made. So the bills presented to me are presented to the owner, and only upon disbursement of fund they are entitled to.
And you're approving,
My lord,
additional work is being approved by not looking for.
not talking for my lord. That is there in page number in my affidavit, page 266, my lord. 266. They say that with reference to the subject cited, your letter number so and so dated 16/3/2016, it has come to my knowledge that additional amount of 56 lakhs is required for UV radiation work. For this additional amount, college will definitely communicate with the government for granting said amount and for completion of the work. As you have awarded, the whole matter is concerned with the union government and
the
more
union
particularly
has
Ministry of Sports.
Rejected in toto.
Yes.
You are therefore requested to complete the work. You are therefore requested to complete the work
As soon as possible.
as soon as possible.
Who
The
said?
money will be released on getting grant from the government.
So petitioner knows after getting grant from the government says that we are not going to grant. So you knew it. You did it at your own risk.
No,
Yes, my lord.
So you knew it. Why did you ask, take the work?
yes, Lordship, there are.
You've taken the money and left it, isn't it? Indian government wants to only show that we have given money to do the work. Whether it is half completed or we are doing work, we are not worried.
That was there.
So it was completed, my lord,
There-
but then
that's
without that UV coating
No,
actually.
with that
the
money,
process
if
should
it
have,
is,
my lord, not
with that
been
money, if it is
sustained,
half completed also, we don't mind.
my lord.
That's the union government stand, isn't it?
In a way, my lord.
Was it for very synthetic that now there is something extra?
No, this is part of the track only. This track, my
See,
lord,
look,
without,
Understood, but the fact remains to have a completed work, this additional thing needs to be done.
Yes.
Now, just for example, tomorrow in this particular building, you need everything is there, the AC vents, everything is there. Then later on says, oh, this contract work, we did not put the AHU. Then how could the code without windows run without the AC? And therefore, the central government said, no, or the state government in this case say, we never thought of, we said that you will complete this thing at 96 lakhs and this is the total 96 lakhs. Do whatever you feel like. Where will the not looking pool will get the money?
We should have put up the proposal. Before the
Understood. So therefore, the question is, the not looking pool made a mistake, I suppose, a mess out there that without the approval being taken, they have gone for this further extension or additional work. But be that as it may, the work had to be done. I think, Mr. Adhikari, you should impress upon the central government to do it. At the end of the day, the work has been done.
Already about 5.5 taken out grant to single thing. That was very clear, and that forms part of the petition. They have annexed the document of annexure 13, page 155.
But I have not received 5.5 crore. I have received only 4 crore 91 lakhs. That was my work. Oh, yeah, that is my work.
Your work order is how much?
4 crore 91 lakhs.
Your work order is 4 crore
Yes,
91.
yes,
So you got that.
yes, I. But
And what else? There is an
now
additional,
38 lakhs 92,000 is pending.
out of that 10 lakhs you got.
No, total 48 lakhs 92,000. Out of the 10 lakhs paid, now 38 lakhs 92,000. And the stand of the government is that they have paid 5.50 crore. So I have received only 4.91 crores.
No, the total project cost included 7% commission charge to us also. In fact, we have
No, you
not
got
kept it
four
also.
4.91
91 plus 38.
plus 10.
So 5 crore 91, 5 crore 1.
Now 38 lakhs 92,000 pending.
And this has gone in the commission.
My lord, no, this does not include the 7% commission charge of NPCC.
So my question is therefore, where is the missing 49 lakhs?
Yes, amount.
College says that they have paid it to the emphasis.
Where is the missing the 49 lakhs?
College had an agreement with NPC.
I think you should ask for a utilization. Have you asked for the utilization or not?
Already utilized.
No, have you asked for the utilization certificate? Mr. Adhikari, have you asked from them the utilization certificate or not?
The first certificate was given to us, and only one of that amount of 2.5 was released.
The second certificate, have you got the utilization? Ask that. Then only we'll know where is the 49 lakhs hidden,
Missing amount.
Huh?
That missing amount.
isn't it?
9 lakhs থাকিব balance
Look. The instant dispute is in relation to non-payment of the dues. For construction of a, what is that? Track,
Synthetic track, Lordship.
synthetic track. Synthetic athletic track. The central government have given a grant to the North Lakhimpur College, an amount of rupees 5.5 crores. The North Lakhimpur College entered into an agreement with National Project Construction Corporation Limited for the purpose of construction of the said synthetic athletic track. The National Project Construction Corporation Limited thereupon given a subcontract to the petitioner. The subcontract which was granted to the petitioner was for an amount of rupees 4 crores 91 lakhs, isn't it?
Yes,
ma'am.
49,200.
202.7.
Eight number, likely. In the meantime, while the construction was carried out, there was a necessity for additional work for giving a full effect to the synthetic track. Accordingly, an additional work order was issued to the petitioner by the National Project Construction Corporation after taking the approval of the North Lakhimpur College. The petitioner submits, the counsel for the petitioner submits that the amount of rupees 4 crores 91 lakhs have been duly received. For the additional work, the total amount is how much? 48 lakhs.
48 lakh.
How much?
48 lakhs.
48 lakhs and odd.
92,727.
And out of that, the petitioner have received a further amount of rupees 10
10.
lakhs. In other words, the petitioner for the entire work have till date received 5.01 crores approximately. And the petitioner is further entitled to an amount of around 38 lakhs. The stand of the Union of India is clear that they have already paid 5.5 crores. However, They have received the utilization certificate only to the extent of 2.5 crores. 3 crores. The question therefore arises as to who is who has under whose custody the remaining 49 lakhs is there. It is the opinion of this court that the Union of India, who had issued the grant to the North Lakhimpur College, can ascertain by making necessary queries. Who is the your respond number? Respond number 3 and 4 are directed to take up the matter with. Okay, respond number 3 is that 3 and 4 are directed to take up the matter with the North Lakhimpur College. In respect to the utilization of the grants so submitted and place a report before this court on the next date. This matter on 18th of September 2026.
Amen.
Then we know where is the cat. Yes, any urgent matters? Mr. Samaria, your case is not. You are doing social service by keeping the couch.
My lord, my lord, really, the institution faces very financial hardship, my lord.
Financial.
Really, my lord. Next week, my lord, any date, my lord.
Yes, Mr. J.K. Goswami. You want the Gosala to be closed down? Do something.
My lordship, 61.
Finally. I am seeing Mr. Samaria during the motion days. I know that this is a case of that Gosala.
Yes, lordship. Yes, lordship. Yes, lordship.
And if it is
Now,
on a
lordship.
Thursday, then there is one other case of that particular person
My lord.
of the High Court is there in some employment in some place.
My lord. Next week, my lord, any date, my lord, little bit problem, my lord. The institution really facing hardship. The cows otherwise will be out.
We filed our reply, lords.
Everything is ready, my lord.
Affidavit in opposition. Again, lords, a reply, it is bigger than my affidavit, lords.
Every
I have
document
to
we have
give
submitted.
Entire reply, lordship, and have to take some instruction also from the department.
Anyways, all the councils may take a date wherever the interim order is there, we extend it. If there is an urgency, then we have it immediately.
Well,
And if there's no urgency, they can, if there's an interim order, we'd like to have it sometime in the month of September.
my lord, lords. Deeply.
My lord, item 32, my lord.
What is that?
32, my lord. My lord, petitioners.
What is the matter about?
My lord, the matter, well, your lordship may remember, petitioner is an empaneled valuer of the bank, my lord.
Huh?
And empaneled valuer of the bank, my lord. And is,
Oh, that matter.
yes, my lord.
I've asked them to take the obstructions that whether natural justice was followed
Yes,
or not,
yes, my
and the
lord.
other
And-
is whether it would be a stigma upon them and all.
Yes,
And Mr. So and so Hazarika has placed some RBI guidelines out to the stated guidelines, which have been filed by way of an affidavit by somebody.
I have filed my updated guideline. As per guideline, my lord, the petitioner, a person has to be issued show cause notice first, my lord.
Chalo, chalo.
My lord, sorry.
Yes, what is it?
My lord, the interim, my lord, may continue item 43, my lord.
Where, what matter is that?
Panchayat, my lord, the election matter.
What happened?
President, my lord, election, I was, my lord, declared to be elected. Eventually, my lord, on a false complaint, the deputy commissioner, my lord, interfered with, my lord, my election. Pursuant to that, my lord, this honorable court has passed an interim order staying that, my lord.
Yeah, how much item did I go? 43 is being mentioned, means I have been very slow today. Forty?
43, my lord. There's an interesting issue, my lord.
Oh, you are for
I'm for the petitioner, my lord.
Panchayat?
My lord.
Okay, chalo.
Lordship, I'm for the respondent number 6. Leave matter.
Okay, urgency is there?
Lordship may take up, my lord.
No, for the other side will be, they just stay, huh?
Yes, stay, my lord.
So the other side will have an urgency? No. You also don't have urgency.
My lord, I want your lordship may take up, my lord, in that sense. A date may be
They
given.
just stay.
Yes, there is a stay, my lord.
We have it in the month of January.
No, my lord, before. No.
You are,
Lord,
are you the president or not?
I'm the president, but my lord, what has happened? My lord, there is a stay, but now the respondents are not allowing me, my lord, to function, my lord, as a president. Powers are not given to me. That is the, my lord, problem. For that, my lord, I have filed a separate writ petition, but since this is pending, my lord, no order has been passed in that case. That is the urgency in that regard, man. I'm only sitting in the chair.
Look, we have it on. How much time will it take?
My lord, I will take half an hour only, my lord.
Half an hour is too long. Panchayat matter, half an hour.
15 minutes, my lord. I'll
Okay.
take 15 minutes.
You?
So I have to take instruction on that.
How much time you are going to take?
So I am appearing on behalf of my senior, so I have to take instruction on that.
Yeah, private respondent.
Yes.
Who is the Panchayat is Mr. Dotto. He doesn't take for more than 5 minutes. Okay. We'll have it on Monday we finish it up on Monday at 2.
Obligation.
Which is Monday and 2. Final disposal in time order passed earlier shall continue.
Deeply
till the
obliged.
next. Mr. Yes, tell me.
Was that matter regarding locus standi, my lord, where the petitioner, my lord, being
Local?
the locus standi issue, my lord, where the petitioner has challenged my OBC NCL certificates, being a parent of the ward.
Oh, yes. Ah,
Item 39.
that one I wanted to dismiss with cost. How much cost can be imposed?
My lord.
When do you want it? What is the urgency?
Urgency, my lord, only to the extent that the principal has been put at stake and the school, because of all these frivolous litigations, my lord, is not able to pursue with the education department to get, my lord, administrative recognition. That is the.
I thought that let her earn some money and then become rich so that we can impose more cost upon the counsel for the petitioner.
Happy with the dismissal. Cost is lordship prerogative.
I thought a good substantial cost of around 2-3 lakhs upon the counsel for the petitioner. Anyways, we'll have it on September. 8th of September, we final disposal.
Obliged. My lord, 32 next week, my lord.
Oh, your matter.
Lordship, I'm for the respondent number 4 to 7.
43, na?
32, my lord. 32, my lord.
Huh?
32.
32 I have not reached today.
31 last.
Okay. When, how much time?
next
Matter
Monday.
I've already heard it.
Next Monday, my lord.
5. 28th, 27th, 27th, 28th at 2 p.m. Okay?
28.
28th at 2 p.m.
My lord. My lord, item 63, 64, my lord. 63, my lord, item, my lord. The disconnection of the electricity, my lord.
Yes, what is that?
The dead day remind us to upgrade the matter, but we could not upgrade today.
What is the matter about?
Matter, my lord, in the Birubari matter, my lord, eviction matter, my lord, petitioners are still in the place, my lord, they are not evicted, my lord, petitioners, but their electricity is disconnected.
Wait. What about the other matters? Has the other matter has come, Mr. Babuzari?
Pending. Yes.
Today is 19, na?
Yes.
Has the other petition been listed?
Yes, my lord.
Where? Which are those?
Along with 63, 60.
There is a stay operating. There is an order passed by Justice Chaudhary. These are?
Yes.
Hello. Where is Mr. Mr. Babuzari, these are the matters. Have you filed your affidavits?
No, they have not filed any affidavit.
Yes, madam, we are seeking a short accommodation. Madam, the difficulty is that, madam, we have communicated because the DC Kamrup Metro office is being shifted. Today it is inaugurated. All the records are being transferred to a new destination, my lord. From Hangarabari now it is shifted to my lord Rupnagar. today it is formally inaugurated. So the district commissioner has personally, my lord, requested me to seek for a short accommodation, my lord.
There's no urgency then.
Milord, we are concerned with
We
electricity.
giving the electricity.
Yes, only electricity purpose. my lord.
That is it. Because you don't seem to be interested on that, so let them have the electricity
Yes,
functioning properly.
That part, my lord.
Why
That-
should we?
Only
Because-
electricity
Because, my lord, on facts, my lord,
Facts,
we do not know whether they say they are in occupation, but the APDCL authorities have gone to the place and found that no building structures exist.
that is the false.
Therefore, my lord, let me, my lord, file my affidavits. my lord.
Understood, but the fact
The
remains that.
petitioners are not evicted till today, my lord. The petitioners is still exist in their house, my lord.
On encroached land.
So we-
Encroach
we will
is
file-
other
no,
different part,
we are
different part.
Filing affidavits as well as, my lord, other appropriate applications before this honorable court, my lord. Lordship will quickly
Understood, but
accommodate
the fact remains that if you don't do it, why should we? This is not the fact.
that is-
Because on one hand, electricity is an essential thing which is, it is taken along with Article 21, although APDCL right, left and center violates every citizen's right by putting the electricity anywhere. They take away the electricity when it is most required. But anyways, he should be given that.
Electricity may be connected by the electricity department. That's only.
My lord accommodates me for 2 weeks, my lord, with a fee.
2 weeks is too long a time.
That is in the, take look now.
Next. That's what I was suggesting. Let the revenue, since it's been disputed, let the revenue come with the specific where their houses are located. Give us the report.
Oh,
and we can
Mr. Counsel, I don't no, Mr. Borpujari, tell me one thing. What is the affidavit you are required to file? Tell me. You are required to file that you have all, that order is already there.
Yes.
Now, after the order is there, what you the affidavit file is why this thing is more required in public interest. Is the DC going to give you inputs when you have already filed those review petitions to them, make it more clear for you to make a draft the petition? Then tomorrow you may say that Lordship may draft it also for us. We are so incompetent. Something like that. You don't need to because the DC's presence is he needs to only sign it.
I undertake, my lord. I will.
You have already brought on record those things in the earlier round of litigation. He is playing, he is asking on the similar footing of the directions which were passed by the learned division bench. And therefore, it has been stayed by the Supreme Court. He said that the review order would not apply. The other direction of the Supreme Court, the division bench continues to hold the field. So, till the decision is not being taken, or and we cannot be removed. Now, in his facts, what is there? The direction which was passed by the learned division bench was that look here, he is a person you kindly consider as to whether his settlement can be granted or not. Have you seen their order by which they have been asked to vacate? Or is it the DC has the writ petition? In that order which has been asked for them to vacate, it is categorically mentioned that we have looked into it. You are not necessarily required to get all these things. That is another aspect. But the fact remains, it is said that it is required in public interest for that. Are you not a better person than to take those things when it is already matter of record and take an excuse out here that the DC is shifting? Obviously, the DC will be busy. He'll be busy with the inauguration.
Yes, my lord. I take it, my lord. Lordship will kindly accommodate me, my lord. I take it, my lord. It's a fault on my part, my lord.
Well, now.
My lord. Next.
Because you see, you also put this court into difficulty. Once I pass a direction for giving them the electricity, it becomes next to impossible again to decide these other proceedings. You can't delay this because his electricity is also at another question, which is the way on one hand he's saying that he is in possession and therefore invention. So if you don't want to do it, so therefore either we have it in the month of January.
Lordship will kindly fix this matter, my lord.
Meantime, give you the electricity.
Yes, my lord.
Yes, he needs geyser and all.
Only electricity may be
Oh,
connected.
electricity.
I have only simple pen.
Can it be on
One line
28th, my
clear.
lord? With all respect, my lord. 28th is a Friday, my lord. The next Friday.
28th of August.
From
my lord.
June, my lord, disconnected the electricity.
28th of August, my lord. I undertake, my lord, inevitably we will file it, my lord. We will file it.
That matter is fixed on September, my lord.
Which one?
A connected case, my lord.
It is before, isn't it before me?
I undertake, my lord. I undertake.
63 to 66. Mr. 63 to 66. All these writ petitions are connected. Though in WPC number 3875 oblique 2026, the relief sought for is different. Proposal Learning Council appearing on behalf of the Revenue and Disaster Management Department, which as well as the District Commissioner also, as well as the District Commissioner, submits that affidavit on the behalf of the said departments would be filed on or before 27th of August 2026. List this matter on 28th of August 2026. This court finds it relevant to take note of that if there is a further delay on the part of the respondents to file the affidavit in WPC number 3581, 3895, 3896, this court would be constrained to take up the issue pertaining to WPC number 3875 oblique 2026, inasmuch as the issue involved pertains to seeking temporary electricity connections, which the learned counsel appearing on behalf of the petitioner submits is an essential requirement and coming within the mandate of right to life under Article 21. This also. You will provide the electricity provided.
Let me file my affidavit. Once I file my affidavit, Lordship will take a call. Oh, like.